Good morning, everybody. Happy Wednesday. Welcome to TCF Live. It's good to have you all here today. Let's start out with Judge Middleton.
This is Judge Middleton. I'm here in Centerville, and you're in the Calhoun County Jail. Your probation agent had tried to make arrangements for you to get arraigned on these charges last week, but there was some sort of I don't know what happened. Anyway, I was here, but nobody else was. But you're here now. Also present is Jeanette Jackson from the Public Defender's Office for this arraignment. In 2023, on the 4th of July, you got charged with 2 crimes and filed 231586 SM. Count 1 alleges retail fraud in the 3rd degree, which is at Walmart. It's alleged that you took about $18 worth of merchandise. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Then they allege that you were drunk at the Taco Bell shortly after that, and they charge you with being a disorderly person. Disorderly person is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. As I understand it, apparently, it wasn't Walmart, it was Rite Aid. You took some alcohol allegedly from the Rite Aid store without paying for it. As I understand it, at that time, you were on a conditional release from the probation center. And now your probation agent or parole agent wants to get you into some sort of a program. And this hold from Three Rivers is preventing that from happening, which is why they wanted to do this arraignment in such a hurry. Mr. Vasquez, are you willing to plead guilty to these charges?
I am.
Did anybody threaten you to get you to plead to these?
No.
Or threaten you?
No.
Do you understand that if you do plead to these charges, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Correct.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Jackson is here from the Public Defender's Office, but you could also ask me to appoint a lawyer for you. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless you were able to prove your guilt, unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Correct.
All right. What's the plan here for you to get out of the incarceration and go to a halfway house or a probation center?
Yes. The parole house. I did 25
And
months.
where is that?
That is here in Battle Creek.
All right. And you've been unable to do that because of this hold.
Yes. I tried to do a plea by mail while I was incarcerated in prison, but it doesn't seem that went through.
Well, that was me. I didn't want to do a plea by mail on these charges.
Okay.
All right. So how long have you been in limbo waiting to get into your program?
I think 11 or 12 days now.
All right. I'll give you the credit for that time if you plead to these charges. Did you go into the Rite Aid store in Three Rivers on the 4th of July in 2023 and take a bottle of liquor and walk out the door?
I did.
And then did you go over next door to the Taco Bell and pass out in the bathroom?
Correct.
All right. On the retail fraud, I'm going to give you 12 days credit, 12 days, concurrent with the disorderly person. There's a minimum fine of $125. We're gonna make that due by June 1st of 2026. On the disorderly person, I'm gonna order 12 days, credit 12 days. This hold has prevented you from being released to go into the parole place, which is why your agent was in some hurry to get this accomplished. And I don't really want to jam you up on this minor incident from 2.5 years ago.
Thank you, Your Honor.
But you have accepted responsibility by pleading guilty. These will show up on your record. They aren't I don't think they're a parole violation. They occurred before you were, this took place and your agent knows all about it and is trying to get these resolved. All right, I gave you 12 days, credit 12 days. When you get on your fee, you owe me $125. I can't make the fine any lower than that. That'll be by June. So when you get into the place, remember you owe us $125 here in
Yes, ma'am.
Centerville to resolve these matters. All right, you're good to go, sir.
Good morning once again, everybody. Welcome to TCF Live. It's Wednesday, which I believe, if I remember the flow chart correctly, is the new Friday here at TCF. Correct me if I'm wrong. Great to have you all here. Barbara, thank you for gifting a membership. Great way to start out the day. I appreciate that. Let's stay in Michigan, but let's go to Lenawee County. Judge Anzalone.
Is she she's probably in your office, right?
No, Liz, out of state.
Let me find her file. All right, Miss Underwood, I have Mr. Jenkins. Do you need a breakout room with him?
Yes, just briefly, Your Honor.
Right, Mr. Jenkins, I'm gonna place you in a breakout room with Rhonda Underwood. I think you're probably on a polycom, so when she comes back in, I'll bring you back in, okay?
Okay.
So you should go automatically. There we go. Yep, he did. Okay. All right. So Miss Williams, if you could start your audio and your video, please. All right. This is in the matter of the people of the state of Michigan versus Rebecca Sue Williams, file number 23-21606FH. I have I got a prosecutor. I don't know who it is. It just says Lenawee County prosecutor.
Judge, it's Miss McClure's case, but I'll cover.
Okay. Okay, and I have Allison Arnold on behalf of the people and Charles Noe on behalf of Miss Williams. So, Mr. Noe, oh, it's Isaac Steen. Mr. Noe, how would you like to proceed with Miss Williams?
Thank you, Your Honor. This matter is actually set for jury trial, set to commence on February 23rd. I am working on getting more forensic accounting work done on this. I sent several subpoenas, and I'm waiting for an answer on another subpoena from the victim in this matter, actually through their counsel, Mr. Jackson, civil counsel. So therefore, we do have a trial date set, but I don't believe this is really right for trial at this point. This case is an older case, though, to be fair to the court and also to people. But that being said,
Mr. Noe, you are kind of distorted again, and I'm so sorry.
I know it's all right. My new mic is literally en route in the mail. So
okay.
So
we are set for trial on February 23rd. It's my understanding Miss McClure is the prosecutor on this, correct?
We're getting an echo.
Yeah, I have somebody on a phone. I'm gonna put them in the waiting room real quick. Okay, so are you prepared to go to trial?
On this matter, no, we are not. We have more discovery that I'm doing. And I've spoken to Ms. McClure, and we are confident once I have this final piece of discovery, her and I can sit down and figure out some resolution to this case. So what we'd be asking you to do is vacate the trial date, set another pre-trial date in 30 to 60 days, and we'll contact after today. Myself and Ms. McClure will start an email chain with the court clerk to get a new trial date set to keep this matter moving forward, but we are not right for trial this time, no, Judge.
Okay, Miss Adams, could I get the red book, please? This is one of the files that is on my state court administrator list of concern. So I'm not willing to adjourn it out too far at all. So I am going to set another trial date.
Okay.
All right, it's a 5-day trial, you believe.
Yes.
So I have Tuesday, March 10 at 9 a.m.
Looks like Miss McClure is in a trial on James Burton at that time in your court, Judge.
No, because it got adjourned.
Okay, thank you.
And this would take precedence over it anyway, but
Understood.
according to my notes, all my trials for that day have been adjourned.
That would be Tuesday, March 10th through 11th,
Yep.
12th.
At 9 a.m.
Okay.
And let me see here. I'm gonna leave, let's see. The deadline for jury instructions is February 6th, and I'm gonna leave that on because those should be done anyway. And then I'll set a final pretrial for February 25, I think. Hold on, let's see. February 25 at 8:30. And I will get a copy of this out to everybody. And if you need a bench conference, just let me know.
And then is it set to, so trials set to commence on March, on which day again?
Say that again.
What day is trial set to commence?
March 10, Tuesday, March 10,
Okay, and that'll go through Tuesday.
until
Wednesday.
it's done. Tuesday,
Okay.
Wednesday, Thursday, Friday, and then potentially the following Tuesday if we need to.
Okay, all right. All right, I'm in a jury trial already the following Tuesday, but we'll cross that bridge when we get to it.
I don't know what, Okay.
I couldn't tell what he said.
you could?
I could not.
We could not hear what you said, Mr.
I could
Noe.
not understand him.
It's fine. It's fine. I don't, we're set with those dates. Thank you.
Okay, thank you.
It's 97.1 WTCF, where we mix them beat to beat and back to back. Let's move from the sultry sounds of Judge Anzalone to the more classic beats of Judge Dad.
Abston having a seat at the table here, please. Sir, your name?
Richard Scott Duffy.
You're charged with driving on a suspended. You also have a charge of no proof of insurance. I can arraign you and send you to the prosecutor, or I will give you a lawyer, whatever your preference.
I just need to take care of whatever I need to do.
I know, but do you want a lawyer or you want me to arraign you? On January 7 of 26, it is alleged that you did operate a motor vehicle with a suspended license in the township of Brownstown on Telegraph near Andrew at 10:46 p.m. That is a misdemeanor punishable by up to $500 in fines, 93 days jail, costs, or all of those 2 points. Do you understand that?
Yes,
You also have a no proof of insurance, 0-point civil infraction charge. Do you understand that?
yes,
And did you sign, read, and understand an advice of rights form?
yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
yes.
All right, $500 personal bond. I'll enter a not guilty plea. Do you still wish to waive your right to a lawyer? You don't have to post any money.
No,
Okay, so I'm going to enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court during the pendency of the case. You cannot violate a law. You must appear in court as directed. I'm entering a plea of denial on the no proof of insurance, plea of not guilty on the suspend. He's going to take the file to the prosecutor. You go out in the hallway. She'll call you in and you can talk to her then. Okay?
okay, thank you.
Best of luck. Cameron Jamal Cottrell, 25W839925. Your name, sir? You're charged with failure to pay. It is alleged that you did fail to pay $213. If I find you didn't pay and you could have paid, that your failure to pay was not without your fault. You could be incarcerated 1 day for every $10 owed. You could get 22 days. You get $10 credit for each day served. So if you paid 113, you'd only owe 100. You'd have to serve 10 days then. Do you understand that?
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes.
You have the right to an attorney. If you want one, I'll give you one. Would you like a lawyer? It's the charge you failed to pay 213. How do you plead?
Yes.
I'm sorry.
Yes.
Did you fail to pay?
Yeah, I feel like.
You have it all now?
No, I just started working, but I have it for next week.
Anybody force you to plead guilty?
No,
Plea is accepted. Where do you work at?
last call,
How much do you make?
800 a week.
You know you can't, you get paid weekly?
Yes.
You know you can't ignore courts like this, right?
Yes, I know.
I mean, hang on. I know, but you didn't come and talk to us. You didn't do anything. The ticket's been outstanding since January. All I'm telling you is you're much further ahead if you go talk to the judge before it gets to this point. I'm gonna let you pay $50 per week. You can pay more if you want. I'll let you pay 50 per week. You said you're gonna get your first check next Friday, true?
Yes.
Starting February the 9th. If you don't have the money, no problem. Call the court. We'll go on Zoom on or before any one of your due dates if you don't have the money, and I'll give you an extension and everything will work out, okay? Just don't ignore me. I don't like that, okay? Best of luck. You're all set. 50 a week.
Barbara, because I don't think I said it earlier, and apologies. Thank you for the $5 super chat. Very much appreciated.
All right, you're charged with failure to pay $232, and you still owe, since this is a no proof of insurance, a clearance fee on that. You're charged with failure to pay $232. If I find you could have paid and didn't, you could.
She does have a balance now of 277. It looks like she has a suspension on there.
No, I know,
Okay.
but that's okay. So you still owe the suspension fee of $45, but this is a show cause for failure to pay $232. So you could get 24 days. Do you understand that? And did you sign, read, and understand the advice of rights? In other words, if you could have paid and didn't, you could be incarcerated 1 day for every $10 owed. Do you understand that?
Yes.
If you plead guilty here, you're giving up all the rights on that advice of rights form, and we're not going to have a hearing. Do you understand that? You have the right to a lawyer. Would you like one?
No.
All right. To the charge, you failed to pay $232. How do you plead?
Yep.
You failed to pay?
Yes,
You have it all now?
I do not. I have $40 and I can pay the rest completely on the 6th.
Are you sure?
Yes, because I'm working.
If you don't have the money, I'll be glad to give you an extension. You need more time than the 6th, I'll be glad to do that. You sure you can pay all by the 6th?
Yeah, I have $40.
That's fine. That's fine. You pay 40 now, balance by February 6th. Let's say something happens before February 6th. I don't know, you need work on your heater. Who knows?
Call you when I
Go on Zoom. I'll give you an extension. I don't care how many times we have to do it. Just don't ignore me, okay?
so much.
Have a great day. Lacey and Jones, how are you? Who are you here on?
Good morning.
Great Granny, thank you for the $5 super chat. Barbara being a great mod. Barbara is very good at what she does, and we really appreciate her here. So I agree. Thank you.
I did, Your Honor.
Okay, as soon as she brings the file in, I will call your case, okay? She should be
Thank you.
bringing it in momentarily. Janae
Thank you.
Monique Pinkston, 25B147812A. Your name, ma'am? You're charged with failure to pay $900. That is the charge. If you plead guilty, if you're found guilty, you could be incarcerated for 5 days. Do you understand that? Did you sign an advice of rights form here today? You have the yellow advice of rights, John? Or it's a white one? Okay. If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing. Do you understand that? You do have the right to an attorney. If you want one, I will give you one. Would you like a lawyer? To the charge that you failed to pay $900, in fines and costs, how do you plead? Were you ordered to pay $1,295 at the rate of $60 bi-weekly after your fines and costs were paid on the other file?
Yeah.
Did you make those payments?
They,
I didn't ask you that. Did you stay in compliance with the payment plan?
no,
Did I tell you to come and talk to me if you didn't have the money?
yes,
Did you do that?
No.
Why not?
I was having trouble finding a way here. I've been struggling with the ride.
You know how to use Zoom?
Yes,
Well, why didn't you Zoom? I told you you could Zoom too. You can't ignore courts like this, man. Do you?
yes,
Good. Then you and I will get along just fine. Anybody forced you to plead guilty here? Plea is accepted. The failure to pay fines and costs of $900. All right. Now, I sentenced you back on April the 9th
yes,
to 16 months probation, meaning your expiration will be on August the 9th.
yes.
Where do you work at?
Yes, which is still,
Have you done everything else?
yes,
Outpatient treatment,
yes,
victims impact,
yes,
AA?
yes.
You did your,
Do AA, I went straight to the treatment.
okay. Do you have court, did you do court work and community service? All right. Well, tell me how much you make, how many people you're supporting, if any. Do you have children?
Yes.
How many kids? Well, good for you. Boys, girls? All girls.
Seniors,
How old are your kids?
18, 17, and 16.
You married?
No,
How much do you make in your employment?
$20.
So you work 40 hours?
Yes,
You make $800?
yes.
How much can you afford to pay? Do you have any money to pay toward this today?
I don't have anything today, but next week I'm paying for 904.
Are you sure? How are you gonna get that?
My job, when I get paid, my check comes out, I'm gonna pay it before.
Are you sure?
Yes,
I don't need it all next week.
just gotta get it done.
Okay.
I'm complete and everything.
I'm gonna assess costs of $25. I'll go light on you since you're gonna do that. You pay this by February the 9th, okay? Just to give you a few days to get it here. You can go online, you can make your payment with no fees at all if you're paying that in full, okay? So it's $925. Any questions? Otherwise, I'm gonna keep you on probation, subject to all existing terms. Wish you well. Just don't ignore courts again, okay? Be careful out there. I have this lawyer working on waste management. Can you bring the file in?
I will, yeah.
Thank you.
Well, we've got a break in the action there. Let's go. Yeah, let's go back to Judge Anzalone.
Jacob.
2-1. All right. In the matter of the people of the state of Michigan versus Deshaun Cortez Jenkins, file number 25-22494FH. I have Rhonda Underwood appearing on behalf of Mr. Jenkins, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pre-trial conference. So, Ms. Underwood, how would you like to proceed with Mr. Jenkins?
Your Honor, the offer to Mr. Jenkins is as charged to 2 counts of assaulting a prison employee, an E-grid felony of 5 years. The habituals would be dismissed, Your Honor, and we would be requesting a COBS to the low end of the guidelines.
Okay, Mr. Sneed, is that a correct recitation of the plea? And
Yes, it is.
obviously, okay. All right, that's fine, Miss Underwood.
I don't know where we are as far as an advice of rights on this.
Well, I haven't given them yet, and we'll mail one to them, but. All right, so is your client gonna avail himself of that plea?
My client would like to avail himself of that plea, Your Honor.
All right, so Mr. Jenkins, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so can you state your name for the record?
Deshaun Cortez Jenkins.
All right, thank you. So, Mr. Jenkins, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention, hold on, I'm trying to get all my paperwork organized. Is it your intention today to plead as charged to count 1 and count 2, which is assault of a prison employee? They carry a maximum penalty of up to 5 years and or a $2,500 fine. And let me see here. All right, and any subs you have for your prior felonies, although it's not on the felony information, would be dismissed. Do you understand that?
I understand.
And then Ms. Underwood's asking me to COBS to the low end of the guidelines, which I will do. Do you understand that?
I understand.
Okay, excellent. And do you understand that this sentence will actually stack on the sentence you are currently serving?
I understand.
Okay, good. Now, are you satisfied with your attorney and the advice that she's given you?
Yes.
All right, and we are going to mail to you a copy of your advice of rights with a self-addressed envelope to try to get you to sign it and bring it, mail it back in. So you should get that in the mail, but I'm going to go through those same rights with you now, okay?
Okay.
All right, so neither the prosecutor, the defendant, nor anyone else on the defendant's behalf has discussed a possible sentence with the court other than an agreement by the court that I will sentence them to the low end of the guidelines. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Underwood?
Yes, Your Honor.
And Mr. Jenkins, is that correct?
Yes.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
I understand.
Okay, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
I understand.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, which we don't have to worry about, violating terms of condition on bond, you're not on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So the only thing that you could do that would impact that is if you caught new charges while we're waiting for sentencing. Do you understand that?
Your Honor, I don't think that's gonna happen.
I don't think so either, but do you understand, Mr. Jenkins? Oh, he's frozen. Mr. Jenkins is frozen, so I do know that I got to probably back up a little bit when he unfreezes, okay? All right, so I'm gonna skip to Mr. McManus. Are you just setting another pretrial or got a plea? You have a seat then. Okay.
All right, well, they figure out what's going on there. Let's just go back to Judge Dad. A bunch of courts just starting to come online, so we'll keep an eye out for other opportunities as well.
And we'll.
That I missed, I got the date mixed up.
All right, let me go ahead and arraign you, and I'll give you your rights here, okay?
So,
You are charged with a violation of probation. Placed you on probation for 12 months under section 771.1. Not yet.
12 months?
6 months.
Oh, okay, scared me.
My mistake.
Yeah.
My mistake. September 4th. And I have a charge that alleges a variety of different violations. Count one, that you failed to attend your scheduled probation visit on January 9 of 26. That's one charge. Do you understand that charge?
Yes, sir.
Count two alleges that you failed to attend anger management with 4-week follow-up. Do you understand that charge?
Yes, sir.
Hang on. Do you understand the charge?
Yes, sir.
Count three, that you failed to provide proof of completing 1 day of community service by October 31, 25. Do you understand the charge?
Yes, sir.
You plead guilty, or if you're found guilty of any one of those.
Not really. Not really.
Now, listen to me. Let me finish. If you're found guilty of any one of those, you could get 5 days. If you're found guilty of all, you could receive 15 days jail. Do you understand that? Did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer?
Yes, sir. I actually would be willing to give me. I appreciate
I'll
it.
give you a lawyer. I'm entering a not guilty plea. We're going to get you a lawyer. You'll speak to the lawyer, and as soon as you're done, tell the lawyer that the judge said to bring the file back and come on into the courtroom, and I will take care of it. How's that?
All right.
Thank you. Let's go into the defense lawyer, probation. Go out in the hallway, and my court officer will set you up with the defense lawyer. All right?
Thank you.
Thank you. People against. Waste Management, file 26B150191. Good morning, your appearance, counsel?
Good morning, Your Honor. Carrie Barrett on behalf of Waste Management.
All right. Good morning, Ms. Barrett. I don't think I've had you in here before, have I?
I haven't. No, it's usually Sean Powers, but he's on vacation, so
Good for him. I hope he's
filling
somewhere
in for him.
warm.
He is. He and his wife went to Florida.
Nice. I was just there. It was cold for a few days, but
Yeah. Where'd you go?
I went to Naples, Twin Eagles, a golf community
Okay.
with my good
Yeah.
buddy Ron and Nancy Muir, and met, and you know, with their good friend Suzanne. They got a whole bunch of good people there. So
Nice.
I was there for a few days, so it was nice. Didn't want to come back. Anyway, I won't keep you. You're going to plead the overweight with agreed upon fines and costs of $1,700. True?
Correct, Your Honor. We'll plead responsible.
All right. To that charge again, responsible or not responsible?
Responsible, Your
Please
Honor.
accepted. $1,700 fines and costs paid by February the 27th. Okay.
That's great, Your Honor. I appreciate your
Have a
consideration.
great day. Thank you very
Thanks, you
much.
too. Nice
Bye
to
now.
meet you. Bye-bye.
You too. All right. Are those sentences, do you know, with retained lawyers, defendants?
No one's checked in with me at the sentencing, so
Do I have any retained lawyers on those?
Gabe,
Who?
he's retained on the sentencing.
All right, bring them the file, tell them,
Here you
uh, we'll bring them the file, tell them that, and say, if they're not here in 20 minutes, we're issuing a bench warrant. I've had it with these people showing up whenever they feel like. Those were scheduled for 8:30, I believe, right?
At least one of them.
The other one's scheduled for 9:45.
Yeah.
All right. Can I see the docket? Are all the defense lawyers here? Shamarian, do I have anybody out on Zoom, Heather? is everybody just getting into the habit of showing up whenever they feel like?
Nobody
these
is out on Zoom, Judge.
All right, give me
The only-
Shamiri.
The
What's
only
that?
person I have was Officer Paul for the priority waste, but he's in a breakout room with Caitlin.
Okay.
All right, well, he figures out how to find new contestants and not be frustrated about it. Let's go down to Florida, where I hear it's cold. Wade Mercer, first appearances.
Morning. I think you're just being brought back today to tell you that the Gaston County warrant has came through, but it's an ROR warrant. Is that right, Corporal?
Yes, sir.
Thank you. So you were held for Gaston County. They have signed a warrant, but it's an ROR warrant, and what it says is per probation office request. So what that means is the probation officer did file a violation against you, but for whatever reason, the probation officer asked the judge to give you an ROR warrant. ROR stands for release on your own recognizance. So what that means is you will not be held for Gadsden County any longer. When you get out, you'll get a court date there. You'll deal with that then. You've got the bond set on the Jackson County cases. You have the right to post a bond. If you do post bond, you'll be released. And then you need to contact your probation officer over Gadsden County. Mr. Wiggins, anytime your bond changes, you have the right to use the phone. Anytime the bond changes, so you're going to get to use the phone this morning to contact friends or family if you wish to try to post a Jackson County bond. Any questions?
Oh, sir.
Have a good day, sir.
All right, you too.
Thank you. Oda Myrick. Oda Lee Myrick. Mr. Myrick, good morning. Mr. Myrick, you're here because the violation of the probation warrant came through. I know that you've got bond set on your new charges. The VOP warrant has been signed by the circuit judge. Mr. Myrick, it has no bond on it. So what I want to do you this morning, what I want to do is get you arraigned. I want to get you a lawyer appointed if that's what you're asking for. And then we're going to give you a court date, and then we'll see if you have any questions. Would you like to have an attorney appointed to represent you in the VOP?
Yes.
I'm going to appoint the public defender's officer of the 14th Circuit to represent you. Listen to Mr. McDaniel, please.
Your Honor, I'm going to enter plea not guilty. He's got a court date set February 3rd. I suspect they'll take care of it on that date. If not, it'll be March 5th. Nothing else.
February 3rd already has a date. Mr. Mitchell, anything?
No, Your Honor.
Mr. Myrick, you've already got that date of February 3rd. So you should be on that date. And as Mr. McDaniel said, maybe you can get it resolved then. Any questions, sir?
I know.
Have a good day, sir. We have Benjamin Durham. Durham, good morning, Mr. Durham. You're here because you are accused of one count of possession of cocaine. I read the complaint. There is probable cause for the charge. Does not appear to be the strongest case that I've seen recently, but it's there's enough there for probable cause. Your criminal history is not bad. Very little stuff on your criminal history. I am concerned that the pretrial release sheet doesn't show an employment. Are you working?
Yes, sir. I'm working on the side. We're just now my buddy's starting his LLCs up, doing mechanicing. And we're working, doing diesel mechanic work and all that. I'm just waiting to get put on the LLCs.
So how long have you had a real job? How long has it been since you've had a real job? And by real job, I mean 40 hours a week or something close to it.
40 hours a week, maybe like 2 months.
Where was that at?
Or was that at? It was up in Georgia.
Where at?
Box Springs.
Were you living up there?
Yes, sir. I just moved down right after my mom passed away.
Okay. And how long did you have that job?
I've had that job for 5 years.
Okay, that's good. Let me see if the attorneys have any additional information. Mr. McDaniel, anything on behalf of Mr. Durham?
No, Your Honor.
Mr. Mitchell?
We just request to be subject to random UAs.
So the allegation is that the substance, which was supposedly cocaine, was less than 1 gram, and it was allegedly inside a cigarette pack between the passenger seat and the B pillar of the vehicle. Now, the B pillar of the vehicle, is that the vehicle at the back of the seat? I mean, the pillar at the back of the seat?
I
don't know what the B pillar is.
I'm not entirely too
Is that
sure.
what you, Mr. McDaniel, you know where the B pillar of the vehicle is at?
I had no idea. I didn't know what that is.
I used to work in a body shop. I know what a pillar is, but I don't know where a B pillar is.
Car
Okay.
expert, Ms.
So,
Williams.
Mr. Durham, based upon the evidence against you and your criminal history, I'm gonna let you pick between a bond and a conditional release. If you like to post a bond, some people prefer a bond. Your bond will be $5,000 cash or surety. But in these circumstances, I'm gonna offer you a conditional release. Either way, you would have a condition of random urinalysis, whether you post a bond or accept the conditional release. Either way, you would have that condition.
Sure, I'm not trying to
Um,
separate you permanently, but until further order of the court, you're ordered to have absolutely no contact with her whatsoever. You have any questions about that?
No, sir.
Judge Peel, can you hear me?
All right, Bill,
Recording in progress.
Judge
Can
Peel,
you-
I don't have
I
my
can hear
phone.
somebody. I can hear you. I'm in the middle of first appearances. I've got one more left.
You're at the
We are
Jackson County.
too.
All right,
We are too. It's bleeding over somehow, Judge.
Oh, I'm sorry. I got you, Judge
I don't-
Mercer.
I don't know what's going on.
I don't either, because all I can see are my attorneys and
Okay.
are my attorneys both on mute?
We're going to disconnect here and we'll reconnect and contact the IT and see if they can figure it out, Judge, okay? Mr. McDaniel, reconnect in just a moment here.
And Judge Mercer, I've got one more that's going to take less than 30 seconds. It's a preset bond, so I'll log off as well here in about 30 seconds, okay?
Okay, all right. Thank you.
Judge
my
Bill,
phone.
will you
Alright,
give me
call.
that bond amount?
All right, well, they sort out that fun tech stuff. Car talk with Dan. The A pillar are the pillars on the right and the left of the windshield. The B pillars are the two between the front and back doors, and the C pillar are along the rear window. That are the A, B, and C pillars of a car. All right, we're slightly in the way back machine here, so let me see if I can bump this forward just a little bit. All right, we might be going now.
And I did
Yes,
community
ma'am.
service as well as paid a fines.
Okay, and I'm not.
When John muted it out there.
So it appears to be coming through your
Hey,
speaker system.
Judge Mercer, I can still, we're still the same way. We're still got you and me.
Okay, I can post it. I just have.
So it means it's not coming through our system, it's coming through the jail. Back to where we were with Mr.
All right, I think they're
Durham.
good now.
Mr. Durham, do you understand your choice between the bond and the conditional release?
Yes, sir.
And which one do you prefer, sir?
It's hard to.
You gotta make a decision.
Yes, if I do traditional lease,
You got a question?
You're gonna be drug tested either way, Mr. Durham.
yes,
All right, you want the conditional release?
yes.
Yes. Okay.
We'll grant you the
Conditional release,
conditional
sir.
release. You'll have the standard conditions of release plus the special conditions I've already told you about. I'm gonna ask the
Yes.
jail to give you a notice for your next court date. That'll be
March 3rd.
March the 3rd at 8:30 will be your court date, Mr. Durham. The jail will also let you use the phone in a few minutes to try to set up transportation. If you do contact friends or family for purposes of transportation, you can tell them you can be picked up at the Jackson County Courthouse, the conditional release office, in 30 to 45 minutes is when you'll be there and be ready to go. Any questions?
No, sir.
Have a good day. We have Richard Lyons.
Yes, sir.
Mr. Lyons, good morning. Mr. Lyons, you're here because you're accused of one count of driving while license suspended or revoked. Knowingly, Mr. Lyons, there is probable cause for the charge. I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to your attorney, Mr. McDaniel, and we'll see where we go. Mr. McDaniel,
Your Honor, we just asked for a reasonable bond.
Mr. Mitchell, anything?
No, Your Honor.
Mr. Lyons, based on your criminal history, I'm gonna set your bond at $3,500 cash or surety. You have the right to post the bond, Mr. Lyons. Be aware that you do not have a driver's license. You've got a condition that you not drive a motor vehicle. So if you get caught
Yes, sir.
driving, then in all likelihood, you're gonna go to jail with no bond. Mr. Lyons,
Yes,
you'll get a chance to use the phone in a few minutes to try to post that bond. I'm also gonna ask the jail to give you a notice for your next court date, so we don't have to mail you one. And that way we'll know that you get it. And that court date will be March the 2nd at 9 a.m. Mr. Lyons, any questions?
No, sir.
Have a good day, sir. Misty Dykes. Ms. Dykes, good morning, ma'am. You're here in case 23-203 CT. Ms. Dykes, you've already entered a plea of guilty or no contest to this charge of driving in no motor vehicle registration. It looks like, appears I gave you time to pay a fine or come back to court and ask for extension if you wanted one. And according to the clerk's file, you didn't pay the fine and you also didn't come back to court. That's when the warrant was issued. I'm appointing the public defender's officer to represent you, ma'am. I'm going to ask that you listen to Mr. McDaniel, please.
Your Honor, I spoke to Ms. Dykes. She's going to request the court to amend the sentence to add a $400 purge. She has 1 day jail credit, and she'll have to have that paid in the clerk report. Once it's paid, she'll be released. If not, she'll finish up 10 days.
Mr. Mitchell, any objection to that?
No objection, Your Honor.
Ms. Dykes, any questions about that, ma'am?
Just wanna, when can I call?
Right now.
Ms. Dykes, is that what you want to do, ma'am? You want to add that purge?
Yes. Yeah,
I can't hear you.
yes, yes, sir.
Ms. Dykes, I'm going to amend your sentence. I'm going to add a purge on there, which is normally what we do in these kind of situations. Your purge in your case is $400 because you originally didn't have a public defender and now you do. That's why it's $100 more. So it's, as soon as you pay the $400, you'll be released. As Mr. McDaniel said, Ms. Dykes, that $400 has to be paid at the clerk of court's office, not at the jail. The clerk of court's office hours are 8 a.m. to 4:30 p.m. So right after first appearance, you're going to get to use the phone, ma'am, to contact friends or family and tell them about the purge. And as soon as it's paid, you'll be released. But if they don't pay it today until after 4:30, if they try to pay it at 5 or 6 p.m., they can't pay it until tomorrow because the clerk's office will be closed. So make sure you tell them that. If you're not able to pay it, you'll finish the jail sentence and then you'll be released. Ms. Dykes, do you have any questions? Have a good day. Man. 1 day. James Ammons is next. Mr. Ammons, good morning. You're here. Mr. Ammons, for the charge of trespass. Mr. McDaniel has added you to the docket to see if we can get your case resolved. So listen to your attorney, please.
Your Honor, I spoke to Mr. Ammons, 2631 MM. He's going to plead no contest, trespass, understanding he'll be sentenced to 6 months in county jail, 11 days jail credit, $370 fine. He's waived his right to jury trial and call witnesses. He's resolved this case today.
And how many days credit did you say, Mr. McDaniel?
11.
6 months, yeah. Mr. Mitchell's had agreeable with the state.
That is agreeable with the state, Your Honor.
And Mr. Ammons, did you hear that agreement?
Yes, sir.
Mr. Ammons, any questions about that agreement?
No, I do have a question. The agreement, no, I had a question about law. How long?
Could you tell anything about it, Cesar? I could hear Judge Peel and his jail.
Yep.
And he could hear us and ours, but we could only hear him when our jail was unmuted.
I heard Casey Bigelow and Megan Ford too.
So it's.
No other questions, Your Honor.
I'm good, I guess.
All right, so no questions then, Mr. Ammons?
I did have a question. I just want to know
Do you
how
still
long.
have a question, Mr. Ammons? Do you still have a question? Mr. McDaniel tried to answer it. If he
No,
hasn't,
I guess not. He won't let me say anything.
he can't stop you from saying anything. If you have a question, you can ask it if he hasn't answered it. Do you have a question?
Yes, sir. I wanted to know how long a verbal warning lasts because the place I was at, I was at their house Christmas. They were out of town. And they have these cameras that automatically call.
Let me answer your question.
Okay.
A verbal warning is indefinite, lasts forever, unless there's a time limit given at the time it's given.
Okay.
So unless they say next 6 months or next year, unless they say something like that, it's indefinite. There's no expiration date on it.
I
Any other
understand that
questions?
No, sir.
All right. I'm going to accept your plea of no contest to the charge of trespass in case 26-31 MM. I'm going to judge you guilty, sentence you to 6 months in jail, 11 days credit, $370 court costs and fines. Mr. Ammons, I think you've been in the trustee program before, so you know how it works. I would encourage you to check in that program if that interests you, and I wish you the best, sir.
Thank you, sir.
Thank you, Mr. Ammons. We have Zoe Morris. Ms. Morris, good morning. Ms. Morris, you were first appeared on the charge of battery, it appears, and now you have a hold from the Department of Juvenile Justice. Yeah, what the hold says is that.
Charter to the DJJ, I think.
Yeah, it's not actually a hold. What it is, it's a letter from DJJ asking to be notified. So do y'all actually, Corporal, do y'all actually have something I bet she's already been committed. I bet there's an order committing her to a program.
Yeah, it's Dove, Your Honor. She's been committed to Dove, and that's where this battery happened, was at the facility against an officer there at Dove, and they're asking that she be returned to Dove.
Okay. So you've got to have something from a judge to hold someone, not from a probation officer. So I'm assuming there's an order out there committing her to that program, Corporal. You may want to try to look into that a little further, but it appears, ma'am, that if you do post bond, it appears that the Department of Juvenile Justice is going to have a hold for you because there's a prior order signed by a judge committing you somewhere. Ms. Morris, do you have any questions?
No, sir.
Have a good day.
I will say it looks like more likely if the hold is to come out, it's going to come out of Marion County.
Yeah, she's convicted in Marion County, and they placed her in that juvenile facility. That's.
Yeah, they've got to get a hold from that judge, a VOP affidavit or something from that judge, but I'm sure they're working on that. Mr. McDaniel, that's everything I had on my first appearance list. Anything?
Okay, friends, let's go back to Judge Anslow. It seems like they got that connection with the jail or the prison or wherever this guy was figured out, so we can finish that hearing.
But it'll just be a minute, all right?
All right.
Miss Adams, I don't have my phone. Could you message Miss Underwood that I have Mr. Jenkins back?
Okay.
All right, jail Zoom, Mr. Rocket, if you want to just come up here. Yep. All right, so Mr. Jenkins, just bear with us. I'm so sorry. I think it's all the cold weather, right?
It might be.
All right, so Mr. Murphy, you have Mr. Allen, correct?
Yes, Your Honor.
All right, and I have someone at the jail. Are you Cody Allen?
Yes, ma'am.
Okay, so this is in the matter of the people of the state of Michigan versus Cody Isaac Allen, file number 26-22521FH. That file is set for arraignment today, but I also have an extradition file number 26-22515AX. I have Isaac Sneed appearing on behalf of the people and Matthew Murphy appearing on behalf of Mr. Allen. So starting with the arraignment, Mr. Murphy, do you waive the reading of the felony information?
Yes, Your Honor. We acknowledge receipt of said information in the witness list and the discovery demand from the people in this matter. Would ask the court to enter and continue a not guilty plea and set the matter for a pretrial. And then
You waive the reading?
Yes, Your Honor.
How far do you want a pretrial?
I guess whatever fits the court schedule best. Right now, I'm not really sure, depending on what happens with the extradition, I guess.
Nothing's going to happen on the extradition until we resolve this, because if I lose them to another state, I probably won't get them back.
So we're screening him for rehab right now, Your Honor, and so that's why.
I got to tell you, Mr. Murphy, I can't release him to rehab with an extradition.
Okay.
So I mean, his options at this, I mean, he has, like, I can't do that on an extradition. I can delay the extradition to try to resolve this case. But
I understand, Your Honor. I'll reach out to the prosecutor and try to get a resolution as quick as possible and try to be in your before the next pretrial, see if we can get that figured out so that way we can move along.
So I'm going to set this over to I'm going to set it over to February 18, but if you resolve it sooner than that, just call me and I'll bring them in. So February 18 at 8:30 in the morning, we will do the notice of hearing because it's an arraignment. I'll enter a plea of not guilty on this matter, and I will set the extradition over to that date as well. And hopefully we can.
Cody, I'll Zoom with you and talk to you about what's going on, okay?
All right,
thank you, Your Honor.
Mr. Allen. Mr. Murphy, I believe that's all you had with me.
Yes, Your Honor.
You text Miss Underwood and let her know that I do have her client back from MDOC.
Yep, I'll let her know. Thank you, Your Honor.
Okay, thank you.
Have a good morning.
Thank you. You too. All right, so who are you on again?
Curious Swift.
All right. There. All right, and Miss Swift?
Yes.
All right, why don't you guys stand at the podium? Okay, so, here. 1 second. All right, this is in the matter of the people of the state of Michigan versus Carrie Ann Swift, file number 25-22497FH. I have Isaac Sneed appearing on behalf of the people, and just state your full name with your P number because we don't get you out here very often.
Dylan Anthony Rocket, P87681.
All right, and I didn't know if Ms. Spade had your P number. All right. So this is the date and time set for a first pretrial in this matter. So, Mr. Rocket, how would you like to proceed?
We would need a short adjournment. Well, I mean, 30-day or so. We did order transcripts in this case, and downstairs is a little backed up as far as
It's about 90 days.
90 days. Yeah, that would be okay.
Okay. April 15.
Yeah.
And Miss Adams, because Miss Swift is here, could I get 2 notice of hearings? One from Mr. Rocket and one from Mr. Swift. So I'm going to set this over for pretrial on April 15 at 8:30. I thought it was plea today. I would have brought you up sooner. I'm sorry. And have a seat right behind you, Miss Swift, and we will get you a copy of a notice of hearing. And then obviously, Mr. Rocket, if you are able to resolve this, I love to take people on days other than Wednesdays to enter a plea. All right.
Okay.
All right. Very good. So Miss Adams will bring you both a notice of hearing. Thank you.
Thank you.
All right. Okay. Mr. Fry. Is Draquan Dravion's brother?
Yes,
Okay. Because they set a pretrial, but you're entering a plea.
that's correct, right?
Okay. All right, let me let Mr. Glassby in. There he is. All right, Draquan Glassby, if you just want to start your audio and your video for me. All right, so this is in the matter of the people of the state of Michigan versus Draquan Glassby, file number 26-22518FH. I have Brian Fry appearing on behalf of Mr. Glassby and Isaac Sneed appearing on behalf of the people. Hold on 1 second. Right, Mr. Rocket. Here back. All right, so I have received a copy of a plea agreement, and I have received a copy of the amended felony information. I don't see an advice of rights. We've not been able to do that yet.
We did, Your Honor. I filed that with the clerk yesterday.
Maybe it's stapled. Well, you know what? It's probably not over here yet, but I believe you. So, all right. So, as I said, this is a date and time set for a pretrial. I have a plea agreement form that states that Mr. Glassby will plead guilty to counts. Nope, I gotta go off live feed. So.
Well, that was a letdown. I went over there just for the specific reason of being able to see the completion of that hearing. The lawyer never showed up, and then she ended the feed. Whatever. It's TCF Live. It's a Wednesday. You never know what you're going to get here, including judges just killing feeds. Let's stay in Michigan, but let's say good morning to Judge Mom.
Richard G. Serrano, P33828. Your Honor, today I appear as appointed counsel on behalf and with my client here to my right. This being date time for show cause matter. Ma'am, please state your name for the record.
Sir. All right, and good morning. Thank you for dressing appropriately for court. And today is the date scheduled for show cause for your client's failure to pay the balance of our fines and costs of $360.
That's correct, Your Honor. I've spoken to my client today, and today she's brought $50 to pay toward those fines and costs. Your Honor, she works as a bartender. She supports one minor child solely, age 8. She's the only parent that lives with the child. And money's been a little tight, Your Honor. She understands her obligations. She's hoping that the court will replace her on a program of $25 a month. She will pay more if she's able to. With that, Your Honor, we leave in the court's discretion.
Okay, so ma'am, when were you discharged from probation?
I can't remember, maybe a year ago.
Okay, and so, at that time, how much was owed? Have you made any payments since you were discharged from probation?
Yeah, I came and made one.
When?
I can't recall, last spring.
Okay, so did you communicate at all regarding a different payment plan that you would need?
No, because I wasn't aware, money's just gotten tighter.
No, stop. Either you were not aware or you were aware, but you didn't have the money. Don't tell me one thing and tell me something else. It's one or the other. You were either aware or you weren't aware. Were you aware that you still needed to pay fines and costs once you were discharged from probation? Okay, so you made one payment after that and then you stopped. Correct?
Yes.
Okay, so at any point, did you contact in to anybody at the court to notify them that you were having difficulty making your payments and to set up a different payment plan?
No.
Why not?
Sure.
You are sure. I don't know, and I'm not sure, don't work in this court. You made a conscious effort, a conscious decision to not continue with your payment plan. Why didn't you contact the court for a modified payment plan?
Life just got busy. I forgot. No.
It's one of your obligations, correct? And you just forgot it?
Yeah.
Where do you work, ma'am?
Downtown at Returns.
And how long have you worked there?
2 years.
And you're telling this court you don't have more than $50 to pay today, knowing that you haven't made a payment in 8 months?
Yes.
And then you're also indicating you can only pay $25 a month.
I could try to pay more, but I don't have a lot of money. I only work part-time.
So then why aren't you looking for a full-time job if you have a child to support?
Because I don't have childcare.
How old's your child?
8.
Okay, well, does your child go to school?
Yes.
Okay, so have you looked for a job when your child's in school?
Yes.
Okay, and there's also after-school care, correct?
Yes.
Right, so then if you aren't making enough money working part-time to support you and your child and to maintain your obligations, then perhaps you should look for a job that's full-time or more part-time during those hours your child's in school. That would resolve that issue, ma'am. $50 today, the court's going to order $50 per month, not 25. And then we'll begin that. Can you begin that February 27th? It's the last Friday of February.
Okay.
So what we'll do is we'll adjourn the show cause. To a date if you've missed a payment. Giving you the benefit of the doubt, ma'am, we're not going forward with the show cause hearing. If you do not follow this payment plan, then you will be back in court for a hearing. If you pay it all in full according to your payment plan, it will be dismissed.
Okay.
All right? If you'd like to stop at the window and somebody can be with you shortly for your payment, and then you can get information about paying online so you don't have to make the trip down. Okay? Have a good day.
Thank you, Your Honor.
Thank you. All right, and we are on the record in the matter of the City of Wyandotte versus Cameron Griffin Short, 19569. Oh, Mr. DuBois must be paying attention. I was just gonna ask somebody to come grab you and there you go. Thank you.
Always, yes.
Right.
Good morning, Your Honor.
Good morning.
There are the other one here on behalf of Cameron Griffin Shortens, their Griffin Station, the records are Cameron Griffin Short. Thank you.
All right, thank you. And today is the date scheduled for sentencing on your client's plea to the charge of lording or drugs or kept, used, or sold. And the court will note that this was from 2019 and this has been in warrant status for a bit. And then your client is now here to take care of it with the sentencing.
Correct.
And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we've gone over it. He indicates that it is factually accurate and without need of any corrections or additions. The recommendation seems appropriate under the circumstances. You'd like to get this resolved, get this behind you as soon as possible, Judge.
Okay. And sir, if you're to test right now, what is in your system?
Marijuana,
All right. When did you last use marijuana?
approximately 72 hours ago.
All right. Sir, you seem like you're a fairly intelligent individual. Did you read the document that this court gave you with your bond conditions?
Yes, Your Honor.
And so then you read that you are not to possess or consume any alcohol or drugs unless prescribed, correct? And so are you prescribed marijuana for medical reasons?
For anxiety,
You're prescribed marijuana.
for anxiety, I have to renew my NMP.
Oh, well, did you provide this court with a letter from your treating physician prescribing you marijuana?
No, Your Honor. That's how I have to renew the prescription.
Okay. So I'm trying to tell you, sir, that if you have something, a letter from your treating physician, you don't have to go through the steps of renewing your medical marijuana card for this court. However, you don't have a letter and you don't have a valid medical marijuana card right now, do you? Then you're not allowed to use marijuana.
I no longer have access to the letter, no longer have access to the email address that was sent to, which is why I was trying to get it replaced via NMP, or as I would have to apply for it to let it expire. I have access to the address or the email address in which I received it.
Okay. And I hear all that, but you don't have a valid medical marijuana card, nor do you have a valid prescription from your treating physician. So you're not allowed to use marijuana right now, sir. This court ordered that on November 26th. And you just completely disregarded it.
Apologize.
Did you contact the court indicating that you had medical reasons? Tell me about your 5 warrants, sir. Have you cleared them up yet?
Recently just been able to get to a point in my life where I'm able to do anything. And now I'm taking care of it with full time. I'm now able to, and now since I'm able to work full time, I've been able to trying to take care of my legal matters as I'm becoming aware of my situations that I put myself in previously.
Okay. And so, sir, it appears to be that where you're working, you're making good money, correct?
Yes, Your Honor.
Okay, and you're receiving money to almost $300 a month on a bridge card?
Yes, Your Honor.
You work about 40 hours a week, sir?
Give or take, Your Honor, yes. That's all I did. Give me my schedule between 36 and 40.
So it's interesting, sir, that you've indicated that you need marijuana for anxiety because you've reported that you're not under a doctor's care, you're not taking any medications, and no history of mental health treatment.
I have not been under the care of a doctor for marijuana since I was 18 years old. I used it as I was prescribing it because I declined Zofran, other Zoloft, and things of that nature because I don't feel as if I have a mental health disorder from using marijuana. So I feel the need to list that down because I'm not prescribed on any actual drugs such as Zoloft or serotonin or anything of that nature.
Okay. Well, if you are diagnosed with anxiety, sir, that's something that we should need, that we would need to know.
My apologies.
All right, council asks for the recommendation.
Your Honor, I recommend under the circumstances.
All right, the court does find after hearing from counsel, hearing from Mr. Griffin Short, reviewing the report, the recommendation that there is reasonable grounds to depart from MCL 769.5. The court's going to order the following sentence, as it finds the sentence is in the best interest of justice, is reasonable, proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Griffin Short. The court's going to order 12 months probation. You're eligible for early discharge. I'll go over that shortly. You're also eligible under 771.1 status. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. Sir, that applies for marijuana. So we have a treating physician.
If I get my new treating physician, as I currently don't want to take any Zoloft or anything of that nature, can I still use my marijuana, man? Because I use it I talk on the phone for 16 hours a day at times. I cannot go without it. I'm not going to lie. I just can't survive without it. My anxiety is too bad. I'm shaking right now because I'm scared. I didn't smoke today. I haven't smoked in 3 days. Can I get a letter for it? Because otherwise I'm going to be in jail for smoking weed.
Well, hold on, sir. If you were to be in jail, it wouldn't be for smoking weed, it'd be for not following the court's orders. Okay, so let's just be clear on that. Okay, there's nothing funny about that.
It's not funny at all, but I'm asking what you prefer for me to take Zoloft.
Sir, I would prefer for you to utilize the medication that your doctor, your treating physician prescribes. If that happens to be marijuana, okay, that's marijuana. What this court will not accept is if you're walking into a marijuana clinic for a doctor to just prescribe that doesn't have any knowledge of you, your history, anything, sir. That is what this court will not accept. So if you have a treating physician, or if you're obtaining a new treating physician because you don't see eye to eye on your medical treatment with your current one, then that will suffice. But not a medical marijuana clinic doctor. Because you see that one, 2 years later, you go back and see him again. You don't have any follow-up appointments. If you're using marijuana for medical purposes, right, it's medication. You have to have follow-up appointments with your treating physician to ensure it's working properly, just like with blood pressure, with diabetes, things of that nature. If it's medical purposes, you need to have follow-up appointments.
That's not as docket and the medical procedure goes. Y'all never understand.
It's not a what is that?
The medical docket, it's not the procedural of it, but I understand where you're coming from, so I follow your guidelines.
Okay, it may not be the procedure for medical marijuana, but with this court has discretion, right? And so the court's not denying your use of marijuana for medical purposes, but this court has the discretion and the authority to set parameters to make sure that the marijuana is specifically for medical use. And that is one way that this court can ensure to the best of its ability that it's for medical purposes and not for recreational under the guise of medical purposes. Got it? I need a verbal yes or no.
Yes, Your Honor.
Okay, the record doesn't record nonverbal responses. The court's going to also order you to participate in the chemical awareness program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use so you can make better informed decisions in the future, hopefully preventing this matter from happening again. The court's going to also order you to clear up your warrants. I'm not going to order any workforce today. You're to clear up your warrants. Any questions on those conditions?
Oh, Your Honor.
The court's going to order a $100 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, chemical awareness program of $75. That's a total of $1,300. You're going to go over to probation, sir, and you're going to set up a payment plan, and then you'll get your next steps for your instructions, okay? As I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay? All right. Good luck to you, sir. Have a good day.
I'm going to have some stuff to say on this one in hour 4. I'm annoyed. Let's Texas, Judge Stevens.
Everybody checks off the boxes, but James, he colors them in. Which is kind of neat. I like that. It's
my trimmer in the morning.
It's coloring. He colors it in, which is pretty neat. I like it. I like that.
Yesterday, I had a client come in and he said, well, I have a central premise. And I'm like,
well,
so do I. And then he stood up
I
and
got
got
him
to
from my
sign his
mother.
name and he's literally doing this.
Oh, he had them.
And I'm like,
You got them from you?
no, I don't.
Oh.
He's had them for years. And then I said,
My right hand. My right
Yeah,
hand.
whatever
is
I get
my
straight.
mother from my mom. God bless her.
you know,
I got worried growing up, and went, he says, no, you don't have any problems. Does your mother have? Yes, she's got the same thing. Well, you've got it.
genes, yes.
Genetic code, you gotta love it. Thank God, but I'm left-handed, so I don't have that problem with my left hand. It's always been that way.
You know, everything I've gone through, they discovered I'm missing a gene. So I have to wear this thing. I'm on some kind of anticoagulant medication.
Wait. You're the missing link?
Yeah, I'm missing link.
You're the missing link.
You know, I've had 3 blood clots and all. The nurse goes, oh, people normally don't survive 2. And I'm like, oh boy.
So it sounds like you're out to set a record.
Yeah.
All right. Well,
So I
good luck.
I take my medicine religiously.
Anyway, here we are in 25 CR 989, the state of Texas versus Charles Edward Amburn III. That's you, sir?
Yes, sir.
Present with Mr. Macon, your attorney, and the state's attorney. Does the defendant, oh boy, waive a full reading of this indictment? Can we instead proceed by summary?
Yes, Your Honor.
In summary, Mr. Amber, paragraph 1 of this indictment alleges that on or about May 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. DWI. Do you understand what you're charged with there?
Yes, sir.
If it only ended there, you wouldn't be in this court, you would be in a lesser level court. But paragraph 2 goes on to allege, and this is disturbing here, that you have 4, not 2, and it only takes 2 prior DWI convictions to make a 3rd-degree felony for the 3rd one. This is, from what I understand, at least your 5th one. And that's too much. That's too much. It states that in 1985, you were convicted out of County Court at Law number 3 for Jefferson County, Texas for a DWI. December 15th, 1988, 3 years later, you were convicted out of County Court Law number 2 of Jefferson County, Texas for a DWI. 10 years later, in 1998, you were convicted next door in the 252nd Criminal District Court of Jefferson County, Texas. That was a felony then. And then in 2014 here, in my court, the court I preside over, it's the People's Court, the Criminal District Court, you were convicted of another third-degree felony of a DWI. So you have been subject to third-degree felony punishment, well, since 1998, 2 convictions ago. This is disturbing. Would you agree? Can you hear okay? Because I couldn't help but notice that you were having a hard time listening to the lady here, my coordinator. Man, you're having a hard time listening to me, and no one ever thinks I speak softly. They think I speak sometimes in a booming voice sometimes. But
Your Honor, if I may.
Generally, the first felony stops people from committing this crime because they don't want to go to prison. But this is happening too often, sir. Let me read this. He said the policeman that he had 1 beer. What was the blood test? I don't have any information on it.
0.235.
0.235, 3 times the legal limit. That beer had to have been 5 gallons, a 5-gallon beer, at least. That's 3 times the legal limit, 3 times too much. Do you understand what is charged here in these paragraphs of this indictment?
Yes, sir.
This constitutes a 3rd-degree felony, sir, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. Again, I think this is probably the 3rd time this has happened. Then that would be suspended. You would be placed on regular probation for 10 years, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. And then I see here is a recommendation of 20 days in jail. You've been twice ordered to do 10 days in jail on the previous convictions.
The one from 2014, Your Honor, it was, he was actually convicted of a lesser included, Class B misdemeanor on that one.
Say it again.
The October 13th, 2014, cause number 13-17984. He was actually convicted of the lesser included, Class B misdemeanor.
So what happened there? Why did that happen? After that was his 4th conviction. So he only has 1 felony conviction out of the 252nd?
That's correct, sir.
why in the world would that have been reduced? I'm surprised MAD didn't come, which is what they take care of. I mean, and I support them 100%. You don't get lesser exposure to criminality by committing subsequent similar crimes. The punishment goes supposed to go up. Anyway, you have 2 or more prior DWI convictions. So this constitutes a 3rd-degree felony. And you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. And I read what the plan was. It's essentially 10 years in prison, probate that for 10 years. And there would be terms and conditions of probation, which were similar to the other 4 probations I presume you were on. Were all these probations, or did you just do time on some of these misdemeanors? Do you remember?
You remember if you did time?
You have the prior convictions, right?
Yes.
What does it show, please?
I did. Mistake?
Yeah.
I did, on the 1052nd, Mr. Giblin, I did 7 years probation. I had, intoxilizer in my truck, Smart Start for, 7 years and 300 hours community service. And, the last one I got back in 2013 or 14, it was 2 years probation and several hours, 100 hours, I believe, for the community service. And, a couple of $2,000 fines, sir. And, I completed the probation both times in the community service and paid my fine. And, I had the intoxilizer the second time. The last time I had one, 2013, I believe it was. The final disposition was in 2014. I think I got the DWI in 2013, but the final disposition was in 2014. But 2 years probation, and I had the intoxilizer for I think 3 years, sir. I've got an intoxilizer in my truck right now.
Well, that was a condition of bond.
Sir?
That was a condition of your bond.
Yes, sir.
When you were arrested this time.
Yes, sir.
But it's not because you want to do it. It was because it was ordered. And so this is at least we're dealing with your fifth DWI this time. Correct? This is your 5th one today.
Yes, sir.
Well, do you have from this?
Yes, Your Honor. He got 20 days on one of the misdemeanors,
Which one,
60
please?
days. That's County Court at Law number 311. That was from 1985.
Okay, that's the first one here of the 4.
April 1998. That's in.
No, that's just, where's 1988's conviction? Out of County Court at Law 2. 137400.
20 days in 1988.
You got, and in 1998, 75446, the 252nd.
7 years probated for. And probated for a term of 7 years.
I guess he had to spend some time in jail. That's
Yes, sir.
what statutory required, 10 days.
Something. What's the anything's impressions? You were here maybe for 7 years.
Think so. He has called you today.
There's two kids that are the same age.
I took the Evelyn Manning speed reading course. Would you mind me?
So that's.
Have to read that one. I know it's a packet of
10
stuff.
days.
It's always a packet of stuff.
10 days, jail.
Yes. And then we get to the 2014, and that was reduced to a misdemeanor. And what did he receive?
Suspended. He received a 180 days jail that was suspended, and he was placed on community supervision.
There was a requirement, I think, if it's a misdemeanor, then at least 3 days.
They're normally giving credit for that.
Yes, sir. Oh, they don't, they actually don't go into jail. They just give them.
Sometimes they do,
Really?
but if they have a good lawyer.
Well, I mean, it's a mandatory 3 days. How can they get credit if they didn't serve the time? Uh-oh, you're
When
looking
they,
at,
when they get arrested.
that's one.
One. I think it counts.
They counted for 3. I'm not sure that the people who are advocates of this against this kind of behavior feel like that's fine. Because it's good. All right, is that okay? All right. So again, you're looking at a 3rd-degree felony, and you would be found guilty, sentenced to 10 years in prison. That would be suspended, and you would be probated for 10 years, $500 fine. You understand that all of this?
Yes, sir.
If I follow this agreement, placing you on probation for, I guess, a 5th time.
That's a great question.
Is that right? Is he on probation on all those others?
That's correct.
Then you have no right of appeal of your case. Do you understand if I follow this agreement?
Yes, sir.
How do you plead this guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which recites 4 prior convictions of operating motor vehicles while intoxicated, 4. And at least one of them being a felony out of those 4. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true voluntarily? And because these allegations in this indictment are all true and correct?
That is true, sir. Yes, Your Honor.
If I make it a misdemeanor. Then criminal mischief and this which I know. This mayor have a real constitution. Issue is.
Can you show what the state's exhibit 1? Did you sign that document? Understand it? Discuss it with your attorney. Are the contents all true and correct? Is everything true and correct there?
Yes, sir.
State's exhibit 1 is tendered into evidence.
No objections.
And without objection, it's admitted. Hold on, I'm gonna let him look at one other thing. And on this page, is all of that true and correct?
Yes, sir.
State's exhibit 1 is tendered into evidence, and without objection, it's admitted. Among other things, sir, this states that you are mentally competent to enter your guilty plea.
Yes, sir.
You have a little hearing trouble, but I think you're alert mentally. You understand and appreciate the consequences of pleading guilty. You were competent to enter this guilty plea. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony of operating a motor vehicle while intoxicated. As I find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. And there's sufficient evidence here supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. Pre-sentence report is waived, I presume.
Yes,
I follow this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison.
Sure. Oh, actually.
You must have an auto ignition interlock system in any vehicle you operate, which requires you to pass the breath test before it will start. You must complete a Texas DWI repeat offender program. We're about to go into that. Yes. Everybody buckle up. You're going to go to jail for a while. This is your fifth DWI. You have been placed in jail 4 separate times before, and you are still out there driving while intoxicated. It's a 4,000-pound missile. It has to be operated soberly and responsibly. And 3 times the legal limit is not responsible behavior. You're asking for what when I assess this to do it on weekends. Why is that?
Your Honor, Mr. Ambert is employed as a rigger, gainfully employed, and would ask for the weekend time so he can take his job.
All right. Anything from the state? Because I'm about to drop it.
No, Your Honor.
180 days. You can do it in successive weekends. It'll take forever. But at least you won't be on the roadway putting people in harm's way. You have had the 4 previous convictions did not deter you. And we're just lucky that somebody wasn't, if there wasn't an accident where people were injured or killed. This is irresponsible behavior. And I know the judges have talked to you in the past, but you're still doing it, sir. Are you an alcoholic? I'm going to be right frank. Are you an alcoholic?
Under the definition of alcoholic, yes, sir.
What are you doing about that? What are you doing to help yourself?
I have not had a drop of alcohol since the day I was arrested in May 17th.
You have been
8 months.
No, but you've been dealing with DWI charges and convictions since 1985. That's 40 years. 40 years, and you still are not getting it right. The most I can assess is 180 days. You seem like a nice person, but 250,000 people in this county need to be safe from irresponsible behavior like this. It's repetitive. So you're going to do 180 days. And that's going to take a long time. You're going to have to report in the jail on or before 6:00 p.m. every Friday. They will release you 2 days later so you can be able to work. You're talking about, at that rate, 90 weekends, almost 2 years, every weekend. But I really don't feel sorry for you. I'm here to be fair and impartial, but also see what's in the best interest of the people and their safety and well-being. And you're not.
I think it's best.
I'm really considering just ordering you not to operate a motor vehicle on my watch,
This was time.
which I think I could do. I don't see anything in the Constitution that states you have a right to drive. But shame on everybody involved the next time this happens.
Oh, it's clear.
Because you have shown a propensity to continue to do the wrong thing. And it's all about your self-interest. You know, everybody else is put in harm's way, but you're getting high and getting intoxicated. You're not putting others ahead of you like you should. You're just concerned about your inebriation first. Getting high, getting inebriated. Everybody else is going to be in the way, and they're the vulnerable ones. You can't think that. It's selfish thought. I don't think you're a selfish person, but you are portraying yourself to be for 40 years. Anything else?
No, when is the total time to begin?
This weekend.
That's the 30th. Friday the 30th.
Whatever it is, day after tomorrow. Today's 28. Yeah.
If we make it.
Do you attend an Alcoholics Anonymous program? You're going to. I'm going to throw you in that too.
So you do that.
That's important. I think they're helpful. But whatever has happened for 40 years is not working. And I don't want a catastrophic fatality event happen on our watch, because that's what happens when a 4,000-pound missile hits another car. Like this can happen. All right, Mr. Amber, please see the probation officer. He will go over everything and we will begin probation.
Okay, so I got to catch up on things here. That took a little while. Couple things I need to cover. But first, what struck me was that he talked about the 250,000 people in the county. Here's the saddest thing. Based on what we see in his court and in Judge West's court, and even in his name escapes me, Judge Rubber Gloves, even what we see there, that county, as sad as this is to say, has even more to worry about than this guy. How sad is that? Because this guy is horrible, but it's messed up there for such a small population. Barbara, thank you for gifting a membership. I think you hit your target, so that's super cool. Speaking of memberships, Daniel's Nina, thank you for becoming a channel member. So channel members, Judge Holmes, thank you, Michael. So channel members, so what you get when you become a member of this channel is the ability to join us on the pre-show, which happens a half an hour before this show, so be sure to check that out. You get the ability to call in and talk to me during the 4th hour. This case that we just saw is another case I'm going to be discussing during the 4th hour today. You get a discount in the store, early access to videos, a whole bunch of other stuff. So thank you again to Daniel's Nina for becoming a member, and thank you, Barbara, for gifting one. So very cool. And then also real quick, we were discussing in the chat possible nicknames for Judge Stevens. Judge Sappho was suggested. I would say if we're going to go Sappho, we might as well just go all the way to Fafo. But it's up to you. Michael, thank you for gifting a membership. But also that was suggested was Uncle Judge. I like that, but not for him. We need to find us a southern backwoodsy kind of judge. You know, somebody look at you and go, yeah, that guy over there, he's my Uncle Judge. That needs to be where that goes. But we'll keep an eye out. I'm going to keep that one written down because I like it. It just has to be the right person. Anywho, I paused it, but new contestant with Judge Stevens, so let's just continue to ride with him.
And you are charged here with the state jail felony of criminal mischief, which carries with it up to 2 years in the state jail. Have you ever been in trouble with the law before, sir?
One time back in 08, went to prison, got out, completed parole, and never been in trouble.
What was that for?
Drug possession and possession of currency.
Okay, you fixed that.
Yes, sir.
You're gonna fix this?
Yes, sir.
You're okay, you know right from wrong, and you fixed it. And that was when? A long time ago.
Yes, sir.
All right. This kind of a freakish event, a weird thing, we'll fix it. There's a way to fix it. I think you know what's right, and you foul up. Welcome to planet Earth. We all do. How we fix our mistakes and deal with them. That's the test of character. How are you going to deal with this? Responsibly?
Yes, sir.
Good, good. Mr. Weisinger here is a good man. He will guide you through all of this. What do we want to do today?
Your Honor, today, we got all our discovery, got all the pictures and everything.
That's
with the client. So that's a step of, I got with the prosecutor, they gave me an offer.
Okay.
We
considered
considered it, we countered offered and said, we've been willing to do this to resolve the case. And I think she's
reached out to the complainant witness this morning after I received the counter offer, and I didn't get an answer. So I sent him a text message asking him to call me back, which is what happened the last time I talked to him. So we just need a reset to give me time to run that counter offer by the complainant.
We're not gonna, this is an older case, but I'm gonna wait 2 weeks and that's it.
That's fine.
They'll probably call today.
That's correct.
But is 2 weeks good for everybody?
Yes, sir.
All right. Get a resentence. Thank you.
Thank you, Judge. Well, hopefully next time in front of it, we'll have it resolved.
Yeah, that's good. That's a good thing. Resolving is always a good thing.
Yes, sir.
Right there.
I have a few minutes.
All right, I'll keep an eye on that court while they rack up more contestants, but let's go back up to Judge DeSanto.
Out from having.
Do I know your client?
Yes, you do, Your Honor.
I do know your client. Okay. I think I haven't seen you in a little bit. I think you played football with one of my boys,
Yes, ma'am.
or both of them. I don't know.
Yes, ma'am.
I think it's been a bit.
Yes, ma'am.
Okay. Any objection to this court continuing?
No, Your Honor. Thank you.
Okay. All right. And so today is the date scheduled for the arraignment pretrial in this matter. And counsel, as to the arraignment.
Your Honor, I'm going over the advice and rights form with my client. I've advised him of what he's charged with and penalties that may be imposed. We'll wait the formal reading. Ask the court to enter a plea of not guilty. There should be a signed advice and rights form to file, Your Honor.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then as to the pretrial, counsel.
Your Honor, I've met with the prosecutor. There's a proposed discovery order that I respectfully ask the court to enter. I'd like some time to obtain and review the discovery material so I can advise my client accordingly. And if the court will provide it with another pretrial hearing date in 3 or 4 weeks, I think that should be adequate time, Your Honor.
All right, the court has signed the discovery order. We can adjourn this to February 18th.
The 18th is fine, Your Honor.
At 1:30.
1:30 p.m. As to bond counsel.
Your Honor, my client is posted a $250 cash bond. Your Honor's aware of the gentleman's long-time presence in the community. He has no pending matters, any other court, he has no priors. He's retained counsel. I'm satisfied he'll appear to comply with all orders of the court. And ask the court to simply continue to bond as said.
Okay, and sir, where is it that you work?
Me? Pardon, sorry. I work at Ashley Furniture out of Florida, Your Honor.
Okay, and are you currently on bond in any other jurisdiction?
No, ma'am.
You're not currently on probation parole anywhere?
No, ma'am.
Ever failed to appear in court for any reason?
No, Your Honor.
If you were to test right now, what's in your system?
Marijuana is in the system, ma'am.
When's the last time you used it, sir?
I used it yesterday.
Do you have a medical reason to use it?
No, Your Honor, I did not.
Moving forward, you're not to possess or consume any alcohol or drugs that are not prescribed.
Understood.
All right, the court's going to get, continue your cash bond. You'll get a copy of your bond conditions. Counsel, you'll also get a copy of your discovery order.
Thank you very much, Ron.
All right, thank you.
Nice day.
You as well. Let's go off the record. Council, can you approach for just?
Yes, please.
They always go off the record when I'm trying to quickly eat something, so I now have to talk to you with food bits all in my mouth. Let's go back to Judge Stevens, new contestant.
There's 26 letters, but boy, those can be confusing when you put them together in the word. Okay, 25 CR 363 is called Jasmine Young. That you? Is that yes?
Yes.
Okay. You were charged with a third-degree felony of tampering or fabricating physical evidence with intent to impair its availability as evidence in an ongoing investigation. What was it? Electronic data and records. Okay, and this was in something that was related to the investigation of a homicide. So this carries with it, if convicted, up to 10 years in prison today.
Judge, we're going to set the case for trial today.
Okay, all right. And state understands clear what we're doing?
Yes, sir.
She doesn't do that assertively without having an ace in her hand. Come to know. Or two aces. Because all of this is for forensics, and that's science. It either is there or it's not. Okay, we're set for trial.
Thank you,
Okay,
Judge.
good. Thank you. Great. Let's get it resetting. Trial. And Tom?
May we proceed?
Yeah. Do I have to be here? No, okay.
You don't need to.
See y'all later.
Judge.
Darren, peace. Come on up.
I'm trying. Thank you very much.
What is your middle initial? Your middle initial is D as in David?
Yes.
What is the name?
Dwayne.
Dwayne? All right. You're Darren Dwayne Peace. When you were here with Mr. Kelly, your attorney.
Yes, sir.
And the state's attorney. In 24 CR 1632, you have been indicted. Well, this is kind of a while. For the second-degree felony of assault on a peace officer. And it carries with it, if convicted, no less than no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're charged with? The punishment range applicable here?
Yes.
Okay, what are we doing?
May we have 30 days, please, Judge?
How long has this thing been languished? It's been languishing way too long. Why?
That I'm not sure. I know that Darren and I have only been together a couple of
It
times.
previously had Mr. Dusler on it. I believe he was on it for a little while.
Okay. How much time? 4 weeks?
Yes, Judge.
Thanks. Thanks, Tom. I know you'll move it one way or the other. Expedient. Please get a reset.
Yes, Judge.
Thank
Thank
you.
you. Yeah.
If Brent Turk were here, I know we would go with all of his cases, but he's not here, so we're going to reset those. Excellent.
All right, let's change it up. Let's go up to Michigan. Looks like Judge Middleton is going to do a sentencing of some kind.
To live streaming because the courts were closed because of COVID. And the court proceedings are to be public. So the solution was we did everything by Zoom. So in the early days of all this, May of 2020 and through that first year, everything was live streamed and the live chat was left on. We didn't even realize what it was. As soon as we were no longer required to live stream, when the courts were open again, the other judges here in St. Joseph County stopped and I continue to live stream my proceedings. And I plan to continue when we move to the historic building. Judge Stutzman, however, is going to have to do some of his matters remotely, either from his office or from some other location while the construction is going on. And so those matters are going to have to be live streamed. So he will be starting his live stream again, I think next week. But he was the one that originally taught us all how to do it. The programs have changed some since then, and he's going to get reacquainted with it. So we'll work on that. Not yet.
Got a hold of him. Hey, Abby, did you get a hold of him, or is Angela? Okay.
All right, good morning once again. We're here for the sentencing in People versus Robert Lee White, 252284. Good morning, Mr. White.
Good morning.
Mr. White was here in a timely manner, waiting. The attorneys have been discussing the matter. Present is his attorney, Ms. Casey Strong, and Abby Stoll is here from the prosecuting attorney's office. This is a FY case, which stands for a felony. It started as a larceny over $1,000, but less than $20,000. This allegedly occurred in the summer of 2025. The defendant was arrested in November of 2025. The felony charges were dismissed, and the defendant entered a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. That was done on December 16th. This alleges a number of thefts of wire and other property that belonged to Forest River. There are apparently videos of some of this, and there's some other evidence. There's a co-defendant, Peggy Lytle, who has yet to be arrested. There's an open warrant for her arrest for this same set of circumstances. At any rate, Mr. White entered a plea, and the matter was set for sentencing. It was set for sentencing on January 21st, and the defendant called and said, I can't get to court. The person I'm riding with has a diesel truck. It won't start. It was very cold that day. Schools were closed. The roads were bad. We simply agreed to continue the matter until today. It had been set for sentencing well, earlier in December and early January, we were trying to determine what the restitution amount would be. So the matter was adjourned from the 21st to today, the 27th, and here we are. Joining us now is Angelique Camfield from the prosecuting attorney's office, and she was attempting to get more information regarding the restitution issue. And it's hard to determine because there were more than one incident. It's hard to value this property. What is its value is for its intended use, or what is its value for scrap? Those are issues that could make restitution difficult to nail down. At any rate, as I indicated, Mr. White entered a plea on December 16th. I talked to him about it. He acknowledged responsibility for this, told me that he stole this property. I'm advised this morning in chambers.
I wasn't aware that I was stealing, sorry.
All right, that you wish to withdraw your plea.
Yes.
All right. You told me you knew you were stealing. I don't know how you would not know you weren't stealing.
There was no signs or anything, Your Honor, and the guy that told me about the place said he's been getting wire from there for over 2 years.
Your Honor, I just want to do a blanket Fifth Amendment. If this is going to be withdrawn, I want to make sure Mr. White understands fully that we are recording and anything he says could be used as an admission.
So Yeah, so don't say anything. The problem is, it wasn't yours. It doesn't matter that other guys were stealing from it. It wasn't your
There was no
property. Stop,
signs up
stop,
there.
stop,
Oh, I'm
stop, stop. And it had value, or you wouldn't have taken it. So apparently there were multiple incidents of this, but the upshot of this, Mr. White, the felony charge was dismissed in exchange for your plea to a misdemeanor. Are you advising me this morning that you wish to withdraw your plea and have this matter set for a preliminary examination on a felony charge?
Yeah, yeah, Your Honor, because I don't see where there was a crime committed, really.
All right.
It was more of a,
Don't say anything more. I'm not unwilling to hear what you have to say, but as your lawyer says, anything you said can be used against you. The law in this area, we discussed this in chambers, whether I agree or not, the law says that when someone moves to withdraw their plea prior to sentencing, the court shall grant that motion to withdraw the plea with great liberality, meaning the law favors allowing the defendant to withdraw the plea. Whether I think it's a wise idea or not isn't part of the equation. You're turning a misdemeanor back into a felony. And what would the next step would be to set a pre-exam conference and then ultimately a preliminary examination. Ms. Canfield, were you able to get any restitution information?
I did get some restitution information, Your Honor, and they're in the process of gathering the documents in support of that. But what I can relay to the court and counsel is that I spoke with Mike Getter, who is one of like the main general managers of the company, and he then has the subsequent plant managers that oversee things. The purchasing agent for the White Pigeon plant is Dorothy, and Dorothy was gathering some documents for the alleged drum of wire that was stolen, some receipts for their scrap metal that when they turned it in for money, they earned $1.26 a pound. And she says each drum, if you will, was 600 to 700 pounds. And there were 9 of those that had been taken over the course of these few weeks. There was also an entire drum of new wire that was taken, which was presumably something the company would use throughout the business. So that was not scrap. That was $1,702. And then they alleged that power cords were taken. I think the defense would be able to point out that in the video, there aren't any power cords in the wagon. There are none that were demonstrated for the defendant to be near, at least on the one occasion that it was videoed. But what the defendant turned it in for, and the receipts that are in the police report indicate that he earned $4,243 off of what he had taken and turned in. So that is the very least amount of what restitution would be, is what he had earned off of it. But I do believe it could go upwards of $14,371, depending upon the court's determination of it after a hearing. The plant manager, for what it's worth, for the defendant and his counsel, had indicated to me that if there were a sanction and a jail sentence, while they would like the restitution back, their main concern is for somebody who is a repetitive theft from their property. They would like some jail, and they may be willing to forego restitution for a jail term. So I just wanted that to be on the record, because I mean, if a plea is withdrawn, we will not be making any more misdemeanor offers, and this will proceed as a felony. And I will try it as a felony. So That is the one caveat for the defendant that's important for him to know, and I know the court's already mentioned it.
And for the sake of the record, I did discuss that in the abstract with Mr. White because it had not been officially extended, but we had that conversation as well.
For the record, the guy stated that he did not care about the wire that I was taking.
All right. So some unknown person, apparently somebody cares about it. So do you wish to withdraw your plea?
Yeah.
I would just state, the court will, for the people, we obviously want to just object to that based upon the fact that there was no error in the taking of the plea. The defendant read his rights, he understood his rights, he had representation. The court was very clear in its taking of the plea. The defendant admitted the offense. And the other portion is, so if there's no error in the taking of the plea that mandates a withdrawal, there has to be a manifest injustice. I don't believe that's been demonstrated by the defense. And I do think also, I don't know that there'd be prejudice to the prosecution necessarily, Your Honor. We have the witnesses available, so I don't know that that element applies.
Well, I don't know about the manifest injustice standard, but yeah, there is a prejudice to the state. For example, let's say this was a plea that was taken on an assault case. And after you entered the plea, the complainant was killed in an automobile accident. And they would be unable to present the complainant.
Well, I feel that there was no.
Stop. I understand what you feel. I don't agree with it, but I understand that's your cockeyed theory of it. My sense of this was a giant gift. The amount stolen is at minimum $4,000 and up to $14,000. If you want a felony, I guess you can have one.
May I say something, Your Honor?
All right, I may stop you, but yes.
I've been in here several times. I've always stepped up, take responsibility for what I've done. I don't feel that, I know for a fact that I didn't take no power cords out of there, and I didn't take no big spool of wire either.
All right, one of the things, a lot of stuff was stolen, and you may not have been the only person stealing.
Yeah, I just, in the.
They've got some issues regarding that, but the other issue is your counsel had met with you, advised with you in good faith, and worked out this misdemeanor plea to your advantage, and now that the sentence is nigh, you wish to withdraw your plea. It's not fair for her to have to continue to represent you in this matter. I will release, I understand that, Casey Strong as attorney. I will allow you to withdraw your plea. As I said, this was in my mind, a generous plea offer. It would be something they could try. The problem is they got a bunch of other much more serious cases than this that need to get tried. And so sometimes you have to make a decision and resolve the less serious cases to make room for the more serious cases. So this doesn't trump a murder case or assault with a hammer or a criminal sexual conduct case, the kinds of things that are pending. So, but you do have an absolute right to have a trial. Where are you living?
Staying in Sturgis.
Are you at the Maple Street address?
Yeah.
Are you really, or just sort of homeless?
I don't know. It's my dad's place.
All right. I would have just set it for a prelim, but we're gonna get new counsel. And it wouldn't be fair to them to appoint it and just set a prelim. So I'm gonna set a pre-exam conference for February 10th. At 8:30. and the preliminary examination for February 17th at 1. So we're back to square one. We haven't accomplished much between December and now. One of the things in here is you denied everything. Peggy Lytle admitted everything. According to the affidavit, she says, yeah, we understood they were stealing stuff. How many times they stole what?
She told him that we.
All right, stop. So you denied anything, knowing anything about anything. You didn't say some version about, hey, some guy told me I could take this. You just denied it altogether. And then she said, yeah, we've been stealing this stuff. They were out here 2 or 3 times this week. So she hasn't been arrested yet. I don't know where she is. I don't know if anybody's even looking for her. But as I said, if you want a felony, I guess you can have one. You can go to prison for this, as opposed to a jail sentence, but you've stated your position. So we'll set a pre-exam conference for February 10th at 8:30. I suspect your new lawyer is going to tell you the same thing that Ms. Strong told you, that this misdemeanor plea was a good offer. But we won't proceed with the sentence today. In the meantime, the prosecutor will continue to work on that restitution figure. So I want you to go out to the counter. We're going to appoint a new lawyer for you, set a pre-exam conference for February 10th, and a prelim for February 17th if needed at 1 o'clock. I'll do an order allowing the defendant to withdraw the plea and allowing Ms. Strong to withdraw as counsel.
Thank you.
All right, thank you.
Thank you, Your Honor.
That is one of the most interesting choices that I think I've ever seen, and that'll be yet another case we discussed during the 4th hour. I've got 3 of them now that I want to talk about when we get there. Reminder to channel members, you can join me in the 4th hour. You can call in, you can give me your thoughts on what I've discussed or anything else you've seen today or whatever. Here's how you do it. You have to be on the Discord server. That's easy enough. I'm sure Barbara will drop a link in the chat if she hasn't already multiple times, so you can get there. So if you're not already on Discord, sign up. Super simple. And make sure that your YouTube account is linked to your Discord account, and then that gives you access to the member areas where you will find the link posted. The link changes every day for how to join me. And just an FYI, since I'm sure some of you are camera shy, you don't have to appear on camera. You can keep your camera turned off and just come in via audio, so we can have the conversation that way as well. And I encourage you to join me. I'm fairly harmless, so feel free to join and talk. All right, let's go back to Stevens. And he's muted himself. Let me see if I can nudge him forward at all. There we
Filed on September 30th of 2025 in this case. And anything anyone wants to add from here? State?
Nothing from
I think we're going to move forward one way or the other. We've had enough time to figure this out, and if we're not going to get help from Louisiana officials, there's nothing we can do. We can only take care of Texas. So what says the defense?
Judge, just I think Ms. Stafford may want to speak to in a few seconds, but I was wondering, so she did plead true 1 to 4, without a whole lot of fanfare. She came in and owned up some stuff. One of our initial settings with the court. Since then, we've been trying to work this out with some court conditions that the court imposed. She complied with rather quickly. The state hasn't been able to verify some of the information, but she does, from what she is telling me, have some plans with MHMR and Spindletop to where she could, if she were to be able to get out and get reinstated, she could go there, get the help she needs. Apparently housing, GED, place to work and whatnot, that she could take advantage and start paying back the restitution that the court has ordered on the underlying cases. She knows she made bad decisions with her probation status, with some drugs and whatnot. But some of that was she was transient and didn't have a home.
How much was paid back on restitution, if any? Nothing.
So, but she was homeless, Judge, without a job. And so if she could get help with getting a job, that might lead.
Didn't stop her from committing a burglary. Didn't stop her from using drugs. Didn't stop her from failing to report. Come on. You know, I mean,
She has been doing well, and she has been incarcerated. She's clear-headed, hasn't had to worry with drugs. I think she's seen the.
I agree. I think
she's seen the error of her ways, and she's.
Incarceration seems what's best for her and her actions. It seems certainly has not proved to be a harm to the general public, except for the costs of the taxpayers to house her. But it's incarceration that keeps her from using drugs, and we know where she is because she doesn't report when she's supposed to. She's been on probation since July of 23, and that's 2.5 years. It's failing. She's had a fair opportunity. Question is, what do we do? And I hear you want to continue on probation. What's the state saying?
Your Honor, she still owes the $23,835.
She hadn't paid a dime.
No, sir.
So, I mean, keeping her out for 2.5 years has resulted in nothing except her spending whatever she can for buying drugs that she's tests positive for: meth, amphetamine, ecstasy, and marijuana.
Just obviously leave it to the court for whatever you think is appropriate for that amount of restitution that's still owed and has not been paid in this case.
Can't you see what I'm saying? Yeah, it's hopeless under these circumstances. If not one penny has been paid in 2.5 years.
Judge, would you like to hear from the Stafford?
Yeah.
Judge Stephen, I know it don't look right. It wasn't right what I've done.
No, it's not. It's clearly wrong. You committed a crime. You committed crimes while you were on probation in the drugs. You bought drugs, used drugs. That's all crime. Every one of those are crimes, felonies. Some of these are felonies. Methamphetamine, possession's a felony, for example. And you didn't report. You scampered off. You went AWOL. We can't help you when you scamper off and disappear. That's the one thing you have to do. If you can't do anything else, is you've got to report regularly, or else you're really not on probation. You're on your own probation, which is failing. Your probation, while you supervised yourself, you went out and got into drugs. So
You should give me a chance to vote.
I gave you the chance, ma'am, when we placed you on probation the first time. How many chances do you get? How many chances? Everybody is subject to the same thing. We told you hey, as you know, the actions have consequences. And if you violate your probation, only one violation is enough to grant a motion to revoke probation. Your probation can be revoked. You can be sentenced up to, in this case, up to 10 years in prison, even though this was a second-degree felony. You were placed on regular probation, so the cap is 10 years, even though it would have been up to 20.
Can you just give me a chance to fight for
You had your chance. I opened the door for you. I opened the door for 5,000 people. Everybody swears that they're going to do the right thing, and 93% of our probationers do. They don't come back and try to explain where they get their drugs, how they got their drugs illegally, committed crimes, and they report. When you don't report, you're AWOL. And that's I'm going to set an example. They have to follow the rules. If I didn't, then if I treated you differently, then people would say, yeah, I didn't report, but I want the Lydia Stafford rule. She didn't report, and then when y'all caught her, then she got another chance. That's what I want. You are fair, aren't you, Judge? Well, I want to be fair. I'm going to treat everyone similarly in the same situation. You can't go out and go AWOL for all this time. You can't go out and use drugs and then say, okay, I'm going to really follow the probation this time. You've had your chance, you know. Let me see a pre-sentence report if you would be so kind. Thank you.
Nothing cases.
Oh, thanks. And you were originally charged with 4 separate burglaries of homes, and the state proceeded just on 1.
No, Your Honor, she's on probation for all 4.
All 4?
Yes, sir.
Okay, hold on. So, all right, then I misspoke. We are also dealing with 23 CR 342 probation, where you were placed on 10 years imprisonment, probation for 10 years. 343, 23 343, another burglary, sentenced to 10 years and probated for 10 years. And finally, a 4th burglary. So you were on probation for all 4 burglaries: 341, 342, 343, and 360, correct?
That's correct.
Well, we need to go through all those.
There's some motion touch.
Well, I know, but she has to enter pleas of truth.
I think she entered.
I believe she did before you. That's what I have it on my sheet, Your Honor. That each one of them she pled true.
Okay, and each of those, you're right. She did enter pleas of truth back on October 6th to the same failing to report any use of methamphetamines. Which case is it that is the restitution?
There was 0341. There was $14,700.
I'm sorry.
03.
So I've got my pen now. Go ahead.
And
Start over from the beginning.
Okay. And 341, it's 14,000.
Hold on. Stand by. Hello? Yes. Yes, sir. Thank you. What do we need to do about that? What do I need to do about it? Yes, it's where on the water tank, where's the water level? Show. There's a device on the tank that is a level. Okay. Good. Awesome. All right, so who is it? Johnson City. You would recommend. Gave us. What about Blanco? You know anybody? Yes, sir. There you go. All right, well. Yes, sir. Okay. Yeah. All right, but thank you for turning out where we're still. What was the level on the propane? Okay, so it was low. Okay. Well, I'm glad we saved it. So, okay, now, I appreciate you so much. Thank you, sir. Okay, well. Okay, we're back here, and that is correct. The defendant had entered pleas of true to allegations in each of these four cases, to allegations 1 and 4. And which is the case that has the restitution on it?
341, there is $14,700 in that case.
How much?
14,700.
Okay.
And then in 360,
yes,
there's $9,135. It's $9,135. And the total that I have is $23,835.
Okay, good. Thanks.
Yes.
All right, anything else to add from anyone here?
Judge,
Sure. Yes.
I get the sense of where this is headed, so just making the argument that Mrs. Stafford has been entirely compliant with everything the court has requested of her up to this date. She has been trying.
No, she has not.
Well, since
She submitted
the revocation.
Those are all serious violations.
Yes, sir. And she pled true, and the court had requested some information from her. She provided the court with information. The state had yet to verify it. She did admit she has a drug issue, which I tend to think mitigates these cases. And as such, if the court is not going to reinstate her.
It's not the drug. It's not. There isn't a condition that you can't use drugs. Yeah, there is a condition you can't commit crimes, and these are all illegal acts. These are crimes that you're committing, not just I'm taking medicine or controlled substances, but it's illegal what you have done. It certainly was inappropriate not to report. If you can't do anything else, you have to report. That's the basis. If you don't report, you're not on probation, but I've been over that. You just failed, and I'm sorry you did, but I'm sorry for the victims of the burglaries. That's the victims here. You're the one who invaded people's homes, and we gave you a chance, and heck, people can get shot for doing that.
Can I just get a chance to get my?
You had your chance when we put you on probation in the first place, ma'am. And here we are with a motion to revoke probation alleging not one, but 10 violations. We've already, let's see. Yeah, we warned you at the beginning, and I know the probation officer is helping as best you can, but anything else? I'm sorry, ma'am. What state say?
Again, Your Honor, just whatever the court thinks is appropriate for this amount of time. Generally, with that amount of restitution, the court has given the maximum from what we dealt with. So that's we'd have to ask for, Your Honor. We'd ask for the maximum. That's what the court generally gives when there's a large amount of restitution that does, and it does sentence someone to a penta.
Okay. Anything else?
Judges said the staff would ask for the minimum. She has been compliant since this has been filed. She's been trying to do better. I think she has an earnest belief that, or earnest effort to try to do better. Drugs did cloud her decision making and made it more.
It wasn't the drugs, it was her choices that fouled up. Here's what we're gonna do, Ms. Stafford. In cause numbers 23 CR 342 and 343, the court finds that you have pleaded true voluntarily, knowingly, intelligently, and also in cause numbers 341 and 360, you have pleaded true to allegations in each of these cases, to allegations 1 and 4, voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater, and your probations are subject to revocation. I am hereby revoking your probations for your violations of probation in cause numbers 23, 342 and 343. Your probations are revoked in those cases, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for time you have served in accordance with these cases, which should, there's just at least 340 days. And that will limit the time you're going to be in prison. It will limit it. In cause numbers 341 and 360, the court finds that there is enough evidence to revoke your probation in those cases. I am going to nonetheless continue you on probation on those two so that you can pay something back to these poor people who I feel sorry for. You still owe restitution in the amount of $14,700 in cause number 341, that burglary of a home, and restitution of $9,135. You're going to continue probation. If you fail on those, you are subject to, as you know, revocation and 10 years imprisonment on each of those cases. Don't think I won't assess that if I feel like you are not trying. You have been on probation for years now, and you have paid nothing back, but you have gotten into drug trouble again, and you have walked off the job and failed to report. That's irresponsible. You have to pay a price for that, and I'm holding you accountable. Anything else to add? That is all. Thank you.
Well, alrighty, friends. So we've talked in the past about the stats for completing probation successfully. I found those stats that I had before, and I pulled them up, and I'm going to get back into them in the fourth hour just to refresh us. Let's change it up. Let's go to El Paso and their jail magistrate court. That's always a good time.
High school. His entire family lives in El Paso. He states, Your Honor, that he has $1,000 to pay towards a bond. He works at Harno's Barber Shop as a barber. He did provide his brother's phone number, 915-291. He has expressed an desire to attend Job Corps. And Your Honor, that money is coming from his mother as far as posting his bond. We would be requesting a PR bond or any reduction that the court is willing to give.
Thank you. Ms. Bryant?
Yes, Your Honor.
On January 25th of 2026, law enforcement responded to a shots in progress. Once they investigated the scene, they came into contact with defendant and his brother, who they learned may have had involvement with the shots in progress call. When they spoke to defendant, he indicated that he had shot his rifle towards a black truck because he saw somebody in the truck had displayed a handgun and he heard shots. And then he gave his rifle to friends who he didn't name, and they took the weapon to some unknown location. So that's where both of the charges come from. He does have a Class C theft from March of 2025. So, Your Honor, for the safety of the community, we would request a PR bond not be granted.
Were the officers able to find anybody of the vehicle that he claimed he shot at?
Based on the affidavit, Your Honor, it doesn't seem that that part, if it was investigated, was not included in the report.
How many times did he shoot the rifle?
Let me see if he indicates. It says he began shooting. I don't think he indicates how many times.
All right, on the tampering with evidence, $2,500 cash corporate surety. On the deadly conduct, 5,000 cash corporate surety. He's going to be under intensive level supervision. Sir, you are ordered not to use drugs or alcohol. Stay in contact with the PR bond office and do not commit any further crimes. In addition to that, you may not possess any weapons, firearms, or ammunitions. What school are you going to?
I wanna join Job Corps, man. I
Okay,
can't
so
go
you
back to
haven't
these
joined anything at this point in time.
No, sir. I
Okay.
haven't. I'm in
You're gonna
the,
have a curfew from 9 p.m. until 6 o'clock in the morning unless you're working or going to school. Do you
Yes, sir.
understand?
Yes, sir, that's perfect.
All right. Thank you very much and have a good day.
So what's gonna happen?
In order for you to get out of jail, you're going to need $7,500 in cash, or you can go through a bonding company. A bonding company is going to charge you 10%, 10 to 15% of the amounts of the bond. So you're going to need no less than $750, maybe up to $1,000 to get out of jail. Understood?
Thank you, sir.
All right. Have a good day.
Have a wonderful day. Thank you.
Next.
This one? I'm sorry, it's because I was just gonna take it one paper, sir.
Okay. Your Honor, the only other GP that I have is Mr. Roacho, and if you give me a couple minutes, there's one more gentleman that's a lockdown here, Jones.
Let me have Mr. Roacho, please.
Okay. Do you want me to change the interpretation?
No.
Okay. You're next, Roacho.
Yes. Buenos días, señor Roacho. Mr. Loving, how's your Spanish?
Good as yours, Your Honor?
Huh?
Not as good as yours?
Not as
I can understand, but speaking is where I get in.
Ms. Bryan, do you speak Spanish?
I do, Your Honor.
Okay. Buenos días, señor Roacho.
Buenos días, señor.
Estamos aquí para tener una audiencia de las 48 horas. Estas audiencias se hacen en inglés y son para que yo considere reducir las fianzas de las personas que están detenidas.
Okay.
Usted tiene dos casos. Uno de esos casos es un delito donde yo no puedo escuchar el asunto ni puedo reducir la fianza. ¿Me explico?
Creo que sí.
Ok. Es el cargo de posesión con intento de destruir una sustancia controlada. Ese caso yo no lo puedo tocar ni puedo reducir la fianza.
Okay.
Usted tiene otro caso, evadir el arresto o la detención. Ese caso es un delito menor. Yo sí tengo jurisdicción para escuchar ese caso.
Okay.
¿Ok? Ahora, si yo lo dejo salir bajo fianza personal en el delito menor, ¿ok? Usted de todas maneras tiene que pagar la fianza para el delito que yo no puedo escuchar. ¿Sí me explico?
Sí.
Y si yo lo dejo salir bajo fianza personal en el delito menor, a partir de hoy, usted no va a recibir crédito en ese caso por el tiempo que está detenido. ¿Sí me explico?
Sí, creo que sí.
Ok. Tiene dos casos.
Sí.
Ok. Ahorita en los dos casos está en la cárcel y le
Ujú.
está contando día por día el tiempo que está detenido.
Ok.
¿Comprende?
Sí.
Si yo le doy fianza personal en este caso
Ujú.
y lo dejo salir de la cárcel, entonces en este caso ya no va a recibir crédito de la cárcel, solamente en este caso. ¿Comprende?
Sí.
Sabiendo eso y como yo no puedo escuchar este caso, el delito mayor, usted va a tener que esperar hasta que otro juez escuche ese caso, ¿ok? Y quizás le reduzcan la fianza y quizás no. ¿Me explico?
Sí, correcto.
Sabiendo eso, quiere que le deje salir bajo fianza personal en el caso que sí puede escuchar.
Pues sí, está bien. Pues no sé qué me convenga más, la verdad. Estoy un poco perdido, pero está
Mr.
bien.
Bryan, Mr. Loving, he's a little confused. Do you want to try? And I
And
can
I don't think I
interpret
could
for
do
you?
any better than you did.
Ok, señor, sí entendió que tiene dos casos.
Sí, tengo dos casos. Sí, sí, sí.
Y entendió que en los dos casos en este momento está encarcelado.
Sí.
Sí comprende que si lo dejo salir en uno, ya no va a recibir crédito por el tiempo que está detenido mientras está detenido en el otro caso.
Ujú.
¿Sí?
Si ya no me va a dar créditos por el otro caso.
Si lo dejo salir bajo fianza personal.
Ujú. Ok, ok, ok.
¿Ok? ¿Quiere que lo deje salir en fianza personal en el delito menor o prefiere esperarse hasta que su abogado lleve los dos casos a un juez que sí pueda escuchar los dos casos a la misma vez?
No sé. No, pues está bien que me dé lo que hizo usted.
Okay, he is requesting a PR bond on the evading arrest. He's got another pending drug charge. Miss Bryant, are you opposed to releasing him? Oh, there's Mr. Cifuentes. Okay, so let's have a bond hearing officer. Can you put his thing on the Spanish channel? Let me put the interpretation button on.
Yes, sir.
Good morning, Mr. Cifuentes. All right, this is Eduardo Roacho. Mr. Roacho is here for a bond hearing. He has two cases. One is an SB9 case, which I do not have jurisdiction to hear. The other is a misdemeanor evading arrest. I had explained to Mr. Roacho that because right now he is being held on two cases, he is receiving jail credit for both cases. But if I release him on the misdemeanor and a peer bond, he will stop receiving jail credit for that case while he remains in jail on the felony case. Mr. Roacho was a bit confused. Mr. Loving, would you try to explain?
Yes, Your Honor. Essentially, I'm looking for another way to say the exact same thing, right? If the judge were to grant a PR bond on the misdemeanor, first thing is you would not be released. You would remain in jail. And as the judge stated, you would receive credit on your felony, time credit for being in jail, but you would not receive any additional credit on your misdemeanor evading arrest charge.
Earlier, he had asked what was best for him, so I think he wanted
O
an
sea, ya ese caso, ese del de palabra ya es como si salgo, pero ya estoy atendiendo nomás el otro, el grave. No, la verdad no sé qué es lo que me convenga mejor. No, no sé.
Would you like to give him your opinion, Mr. Loving?
So, yes, Mr. Racho, at this point, knowing that you're not going to be released, I would wait. I would waive this hearing, which means you would tell the judge you don't want to have this hearing this morning. If for some reason,
Okay.
right, your immigration status changes, or you actually have a shot of getting out in the future, a chance of getting out, then at that point, we could request a bond hearing.
Ok. Ok, me parece bien. Lo único que quería aclarar, no sabía que me convenía más.
In response, Mr. Rocha, I don't think either one is bad. I just think, as the judge said, right, today, even if he were to grant you the largest amount of relief that he could, you still would be in jail. You wouldn't be released.
Okay.
All right, thank you, Mr. Rocha. I will mark you as waived.
Okay.
And I think that's the only person that we needed your services, Mr. Fuentes. Thank you very much.
Gracias.
Yes, sir. Thank you.
Yep.
Okay, gracias.
Gracias, señor.
Next,
Your Honor, I'm gonna move the tablet over to Mr. Jones Caleb.
Jones, what is going on with Mr. Jones?
They took him to rec, Your Honor, so it's a couple floors up.
Hey, what
I go up there to, hold on, sir. I go up there to, they already put him aside for me so that I can take the tablet and hold the court over there.
Okay, give me a second. Let me make sure that the case hasn't been assigned.
Okay.
No, the case has not yet been assigned. Give me a second. All right, go ahead, ma'am.
Okay.
All right, well, they sort out who their next contestant might be. Let's go back to Judge Mom up in Michigan. Boo, and she's muted. We have a problem with muting judges today. Makes it hard to do this program. Get it together, people. Tell you. All right. Let's try Judge Dad. See about that.
Discharged. Your name, sir?
What's the issue, Pfeiffer, sir?
Can you write up? You're moving to dismiss then too, right? Yeah, this was taken under section 771.1, I believe. Yeah, and I said a prosecutorial review date for March 25th. So they're entitled to early discharge, but as far as I'm concerned, when you enter into an agreement with them on one of these statutes, you still have to move to dismiss if you have no problem with that. I wouldn't think you would.
No objection, Your Honor.
Can you just, so you're gonna move to dismiss on this?
Yes, Your Honor.
All right, can you write up a stip for me real quick? Just saying defendant compliant, case dismissed. Mr. Pfeiffer, your name again, I'm sorry.
Wesley.
Would you mind doing that now if you would?
Yes.
Thank you. We're not gonna have any more problems over there, are we, Mr. Pfeiffer?
Sir, I hope not, but there's been problems since I've been in there. Not with me, but with the neighbor. After the,
You guys live on West River Road.
yeah, after the removal.
Hang on, West River and what?
Between Ferry and Riverview Park.
Beautiful area.
It's beautiful, right across from the park. It's lovely. Love it. Been there 35 years.
You know how many people give their left arm to live on West River Road?
I had wonderful neighbors for many, many years.
And now you guys are fighting over there? I mean, I'm not putting the blame on anybody, else. It just seems like crazy to me.
It is, sir, and, like I tried to say, I mean, I got pictures of the, I'm not gonna bore you with them.
No, I'm not, listen, I'm not casting aspersions. It takes two to tango as far as I'm concerned on these neighbor disputes. Oh, wait a minute. Do I know you?
I own Partners Construction. I've been building.
I know, but I'm reading something here. Did you read this letter from this victim here? You- Here, you read the letter that the victim sent, right?
Yes, sir. I'm sorry, this is dated when?
January 26th. I'm gonna read it to you. I'm gonna read it to everybody. My name is Michael Yutchuk, and I received in the mail notice of a Wesley Pfeiffer probation hearing on January 28, 26. Heather, I want you to do me a favor, because I get tired of this. I want you to call up this phone number for Mr. Yutchuk and ask him to zoom in.
Okay,
It's
Judge.
734
Mm-hmm.
658.
Just here's Nova Social.
I want to read this letter.
I understand why.
I have so many friends out there that I don't even know of. You know that?
No, yeah, absolutely, sir.
No, I no, I just want you to know that this is the kind of nonsense. First, I thought probation was an alternative to being sentenced formally. You know what? A clear reading of the statute, I can't say I disagree. But courts have been handling them this way since I was a lawyer in 1983, the 771 statute. It's a delayed sentencing statute. And what it essentially means is somebody's on probation, then they're sentenced. But that's not the way courts have handled this for decades. On probation, a convicted individual would be allowed not to be formally sentenced if they were able to show good behavior, provide restitution, and complete the probation period lawfully. I am appalled that Mr. Pfeiffer, a repeat offender with trespassing, would be allowed to have his probation discharged early. Now, I don't know if he had a prior that was from 2000. He said, as I previously stated, Wesley Pfeiffer's been convicted once before on 12 August 19 for trespassing with his neighbor to the south. Is that true?
Yes, it is, sir.
Not only that incident, hang on. Not only that incident, but I'm sure you have access to the 33rd District site where Wesley Pfeiffer has multiple cases and convictions with the 33rd District Court. He's had a blatant disregard for the law concerning both of his neighbors to the north and south. If you go back further, he was involved with his neighbor to the east, Mateo Argusa. He has a clear and established history of disregarding of the law and respecting others. Third, yourself and the court are going to do whatever you desire with this case anyway, ma'am. He's writing to probation. Wesley Pfeiffer and Judge McNally have a personal relationship outside of the court, so I'm not surprised he's being handled with kid gloves. But please relate to Wesley Pfeiffer. I'm not contacting Grosio Police, the courts, or anyone else concerning his unlawful behavior anymore. The courts and Grosio Police have proven that his behavior is acceptable, and constant slaps on the hand have not changed his behavior. In closing, after I assume the court's discharge his probation, if he trespasses, destroys my property, threatening my children, I will assume he's intending harming them or someone I love. We'll take it from there. I want this gentleman on Zoom.
Judge, I've tried calling him 3 times. He's not answering.
I'm going to call him right here myself. How's that?
Okay.
I hope you don't have to be anywhere because I want to get this gentleman on Zoom. I don't like people making accusations about my integrity. One thing I can honestly tell you, I don't play favorites. Never have, never will. Didn't in 1995. I'm not today, and I won't as long as I'm sitting on this bench. Hang on. Give me my Zoom ID again. 448-415-2913, is it?
Yes, Judge, that's correct.
Chief Duck, I'm not available to take your call right now, but if you leave 2931, I need your call. I'll return your call as soon as I possibly can. Thank you very much. Have a good day.
At the tone, please record your message. When you've finished recording, you may hang up. Press 1 for more options. To leave a callback number, press 5.
Mr. Miachuk, this is Judge McNally from the 33rd District Court. I'm on the bench. I've got Mr. Pfeiffer in front of me. I'd really like you to log on. I'm going to make him wait. I want you to log on. It's the Zoom ID is 448-415 on as soon as possible. I want to hear from you. Thank you. All right. So I'm going to ask you to have a seat. You've moved up to dismiss, and I want to know how I know you. That's what I'm going to ask him, among other things. I get so tired.
Can I get any information on that?
I don't want to talk about it. I'm going to wait for Mr. Yachuk. He thinks that we're friends and go out socially, apparently, or golf together, or whatever else they think. And I want to clarify some things before I dismiss this. That's what I'm doing.
Thank you, sir.
Okay, so we're a little bit in the Wayback Machine with Judge McNally, so I'm going to fast forward and see if we can see the end of this or not. Even if it takes us a little bit of overtime, I don't care. It's worth checking out. So while I do that, I'm going to flip us back to Judge DeSanto, and you can see what's going on there while I work in the background to see if we can see a conclusion to this.
Morning, Mr. T. Serrano, P33828. Today, Your Honor, I appear as appointed counsel on behalf with my client, here to my right. This is date and time set for his early trial. Sir, please state your name.
All right, and good morning. I feel like you've been here recently.
It's about a year and a half, maybe 2 years ago.
Okay, and what was that for?
Drug analysis done.
Oh, and what are you here for today?
Drug analysis.
You know, you are allowed to come in and visit the court just on your own. You don't have to get arrested or ticket to come visit the court. So if you really want to come visit us, ride a bike up here and come visit. You don't have to keep getting criminal charges, sir.
I haven't seen that.
Do you?
I personally do. I was actually speaking to counsel here about finding someone helping to start the process of actually getting my license back, because I'm well and tired of this.
Well, sir, I'm sure that your attorney told you the first step in doing that is to stop driving. How did you get here today?
I haven't drove since I pulled over that. You can check the cameras. I can show you the lift receipt.
No, I'm gonna have you pull up on your phone. Yeah, let's see. As it relates to the arraignment counsel, while your client's pulling that up.
Yes, Your Honor. I've spoken to my client regarding the nature of the charges, all maximum penalties involved. He understands. And thereby, today we wait for agreed.
Bobby, can you grab that, or can you grab that?
Not guilty on his behalf.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then.
I didn't even read over.
I can't read it. I can get you. Okay, what's that?
I didn't even leave a review yet on my ride. If you want to leave 5 stars, it was actually a nice ride.
No, that's okay. You can do that, sir.
Your Honor, as to
Go ahead.
Oh, I'm sorry.
Thank you.
Your Honor, as to the pretrial, my client wishes to retain counsel. So we'd like a short adjournment so he can have that opportunity to retain private counsel. But we at least have this arrangement in place. We're ready for the court bond conditions. He obviously understands no driving. We spoke about that. And so we will see the court on the next arraignment date, if the court pleases, on the next pretrial date.
All right, so, sir. Do you already have an attorney in mind that you are intending to retain?
I guess.
Okay. And so you should be able to do that in 2 weeks?
Yes.
All right, let's adjourn to February 11th. 1:45 p.m. And then as to bond.
Your Honor, my client tells me he's not on probation or parole. no matters pending. And, Your Honor, he is, sorry, sir, helping to work.
Roush.
Is that a full-time job?
Yes, I work about 60 to 70 hours a week.
How do you get back and forth to work?
A coworker who actually lives less than 2 blocks away from me, he's like Long Diaz.
Okay, great. There's a law of personal bond, Your Honor. Obviously, he's very interested in getting this resolved. And he would be retained private counsel.
Seems though you got a little bit of a break on the road, but,
I agree, Your Honor.
We discussed that, Your Honor. It was his father's car as well. They'll take that up at the free trial.
all right, the court's going to order, sir, $7,500 personal bond. You don't have any other pending cases anywhere, sir?
No,
You're not driving in any other city, just Wyandotte?
no, no, not even in Long.
Okay, very good. All right, you're not to drive a motor vehicle without a valid license. So, all right, we'll see you back on the 11th and just have a seat for a copy of your bond conditions.
Thank you.
Have a good day.
Okay, I found the next spot in this hearing from McNally, so let's go back to that.
5-9.
Your name?
Wesley H. Pfeiffer, sir.
Your-
Sorry.
Good morning to you. Your name?
Wesley H. Pfeiffer.
I've called twice. I've had my judicial clerk call at least once or twice. The probation officer even tried to email them. It's unfortunate that I won't have the opportunity to address what I consider to be defamatory, libelous statements made by this victim. Sounds like he's making threats, but it's always easy to be gutless on social media or in places where you don't show up. What is your position?
Your Honor, so Matthew Wayne on behalf of the Township of Grosse Ile, good morning. The township's position has not changed, owing to the fact that, for the agreement that, the township struck with the defendant, and as his probation officer indicated that he's taken all steps and abided by all the terms and conditions of his probation, the township stipulates to dismiss the charge.
Before I go on and do this, I want to make sure. I've never met you. I'm sorry?
No, sir, I'm sorry.
I mean, you look familiar, but I've lived in the community here since I was 1. I mean, my parents moved here from Dearborn when I was 1, and that was in 1959. So I see people, I meet people. I got so many friends that they say that they're my friends. Oh, I'm friends with Judge McNally. I might have met someone who met them at one point. It's just disheartening because an attack on my integrity is nothing I'm going to take lightly at all. It's too bad he didn't have the guts to call back. Case dismissed, motion to the prosecutor. Hand me your form. Well, wait a minute. I got to swear you in first. Raise your right hand. You solemnly swear affirm under the penalties of perjury, the testimony you're given these proceedings will be the whole truth, so help you God. Since October 8 of 25, have you been arrested for any reason?
No.
Any new charges? Any contact with the police? You moved to dismiss?
Yes, Your Honor.
You have the form filled out?
Do, Your Honor. The signature from me.
And for the record, it was under 771.1. You can hand that right to my recorder. That's why when early discharge, if just for the record, as long as accusations are being hurled, prosecutors will typically go ahead and adjourn these when half the time period's up. So that's all I'll say about it. I'm going to figure out what I'm going to do going forward. Case dismissed. Good luck. Thank you.
Okie dokie, friends. So what Judge McNally just said there kind of dovetails into what we were talking about on the pre-show today, where people are very, very bold in their actions when it comes to being behind a keyboard or writing a letter or something like that, but not bold whatsoever when it comes to being face-to-face and personally accountable. So there you go. It's kind of become a little bit of a theme today. Mrs. TCF in the chat now. Good morning, Bethy. So we've got 3 different cases that we can discuss here. Let's label this properly. There we go, TCF overtime. 3 different cases that I've taken notes on that we can discuss today. Plus, I pulled up the probation data that I'd shared in the past, but I think it's time for a refresher because we've referenced it a lot over the last few weeks. Reminder, you can call in. You can talk to me. Link for that is over in the Discord. If you are on the sidebar panel, it's in that chat. So join me. Let's see what you've got to say about some stuff. Okay. Let's start with the not labor statistics. I've got too much data on my brain. The Bureau of Justice Statistics, the BJS. And this is a report from 2022. It's the most recent data that they've compiled. But again, this is on probation and the success rate and how it breaks down demographically. So this is as of 2022. 65% of all probation cases in the United States were felonies. 35% were misdemeanors. Now that's a shift because 10 years prior, only 53% of probation cases were felonies. So it's closer to a 50-50 mix. But we've talked in other areas about how there's more and more laws. It's seemingly easier and easier to stumble your way into a felony. So that's kind of interesting data that it's had such an increase from 2012 to 2022. The breakdown as far as sex goes, 76% of those who are on probation are male, 24% female. As far as race and ethnicity, 52% of those on probation are white, 31 black, 14 Hispanic, 3% other. So that's where that is skewed. Overall probation completion rate. The approximate national average, just overall, is 65% of people successfully completing probation. In 2021, there were 2.9 million adults on probation around the United States. And for most of the 35% that fail, it's due to technical violations where they missed this, missed that, didn't quite do this right. Probation length. If it's success rate by probation length, rather, if it's less than 1 year, over 70% tend to complete it successfully. If it's in the 1 to 3 year bracket, it's about 62% that complete it. If it's greater than 3 years, it drops precipitously and is 55% or less success rate of completing it. By offense type, if you're convicted of a drug-related offense, you're about 65% likely to complete it successfully. If it's a property crime, about 60%. A violent crime, about 57% of those complete their probation. DUI has the biggest success rate at 75% completing it successfully. So that's interesting. And age really matters. If you are 50 years or older, so you're in my club, you are 75% completion successful. 35 to 49, it drops to 65%. 25 to 34, it drops to 60%. And if you are under 25, you only have about a 50-50 chance of completing your probation successfully. And that's really interesting to me for this reason. The older you are, the more successful you'll be statistically at completing your probation. But in the same respect, if you're that old, you would think you would also be more likely to just not be in that situation. So it's interesting how that data works, but there it is. And then success rate by race ethnicity. If you are white, you generally have about a 67% success rate overall. If you are black, it's 57%. And if you are Hispanic, it's about 62%. So statistically, there's not a whole lot of different wiggle room between the different races and ethnicities there in your success rate. I think that sometimes we probably think there is, but statistically it doesn't prove out to be like a huge swing either way, depending on the color of your skin. What if you're in your 60s? Then you're sentenced to retirement instead of probation. I'm pretty sure that's how that works. You can check me on the laws, but I'm pretty sure that's the case. So anyways, I wanted to update you guys, not update you, but go through those stats again, because we've been referencing them a lot in discussion and in chat over the last few weeks, and it had been several months since I'd pulled that out. But that is the situation there. Let's talk about that Judge Middleton guy. So, just to refresh you from the 50,000 foot level, Middleton had a guy in today who was scheduled to do a plea, and it was theft of like a bale of wire, probably from a construction site or something. I don't remember or whatnot. I don't remember the exact situation there, but his lawyer had managed to get it taken from a felony down to a misdemeanor, and he was going to take that plea. But he ended up claiming, it was kind of convoluted, but it was something to the effect of, well, people take stuff there all the time, and this other guy said he'd been taking stuff there for years, so I took stuff too, and I don't see where the crime is. And he steps away from taking a misdemeanor plea, which would have been maybe a little jail time, a little slap on the wrist, to now pushing forward and trying a felony. And that wire was apparently valued somewhere between $4,000 and $14,000. So he ends up in a situation where he's possibly looking at prison. And I'm bringing this one up because you tell me if you think different in the chat, but I think this might be the top 5 for dumbest things we've ever seen on TCF. I don't understand. I mean, it's his right. Don't get me wrong. It's his right to insist upon a trial. But if you're staring down a felony, he admits that he took the wire too. He's just claiming that I think his defense basically goes, well, everybody takes the wire. I think that's kind of how I heard it. But it's got to be the top 5 stupidest thing we've ever seen here, because he's getting a sweetheart deal. And now he's going to risk prison time. But it's interesting. I wrote this down. He made a statement. He said, I've been in here several times, meaning the judge's court, Judge Middleton's courtroom. And then he said, I've always stepped up to take responsibility. That has got to be one of the most back-asswards statements I think I've ever heard. For this reason. You say that you are a responsible guy, that you take responsibility, yet you're also saying that you've been in here several times. Now, I've said before that stuff happens, and any one of us can find ourselves in a courtroom. But if you're there consistently, that's no longer stuff happening. That's you making bad choices. It's just that simple. And I'm struck by the fact, I suppose, that this guy made the choice to continue to do stupid things. That's a gift to, have the slap on the wrist misdemeanor that's not going to mess with your life. And he chose at the last possible moment to risk that. And then the dude just keeps on talking while he's in front of Judge Middleton. That's what really got me. Was he just keeps flapping his jaw. It's stupid. I don't know. Let me know if you think differently in the chat on that one. But that... Great Granny, top 5 moronic. Yeah, for sure. Great Granny shows how stupid he is. Michael, that was stupid. Definitely top 5. We might have to start putting together some videos, some lists of some of the worst decisions made here on TCF from our panel of contestants that we see every day, because it is just that bad. Another one that caught my attention today was Judge DeSanto. She had a couple of interesting ones, but specifically the guy, I think it was the first one that we saw from her court today, who was using marijuana because he had anxiety issues. And I was in and out at the beginning of that, so you'll have to refresh me on exactly what his charges were. But I think there was, I don't remember if he was on probation or he failed to take care of some fines or answer to some charges or something. Whatever it was, he said he had anxiety and that the marijuana was something that he could not live without. However, he also did not have any prescription for it. So she told him that he couldn't use it. But then his whole thing was, well, I don't want to take Zoloft. So it sounds like he has seen a doctor, and the doctor's like, no, the marijuana is not going to help you. You need to try this. Now, I'm not particularly blaming him for not wanting to take Zoloft, because I think my personal opinion as a society, we're way over medicated anyways. So I can get behind that. But I'm not exactly sure how the marijuana is going to help him either. But he was there in front of the judge acting all nervous and then just saying, well, I'm shaking right now because I'm so scared. But this has got me, and I've talked about this in other areas too, and forgive me if I'm redundant or preachy or whatever, but it really bothers me. I'm wondering where all the real men have gone. How in the world did this species survive back in the day when we didn't have all of this modernity, where we didn't have, things like indoor plumbing and electricity and all those things? How do we survive when there was creatures out there that were more likely to kill us because we didn't have the defenses against them? I'm just wondering where real men have gone. Real men figure out how to deal with their anxiety. And I'm not saying it doesn't exist. I get anxious about things. Ask Mrs. TCF in the chat. A couple of days ago, I was really upset and angry about some stuff. But you know what? I handled my things. And I moved on with my day. It continues to amaze me that we see people that can't get through the basics of life without some kind of excuse or some kind of a need to medicate through it or whatever the case may be. And I'm not saying you should or should not medicate. That's between you and your doctor. But I think there's also the whole idea of learning how to handle your stuff, because in the grand scheme of things, are things difficult right now? Oh yeah, they are. Is this the way America should run, the way it's running right now? Probably not. However, when you compare our situation to the situation that 85-90% of the rest of the world is in, we have it real easy. So what are you getting so worked up about? Have we become that fat and lazy that we have to do that? I don't know. It bothers me. Daniels Nina says you have to learn to cope with a certain amount of anxiety in your life. Exactly. Where's it written that life should be easy and comfortable? I mean, don't get me wrong. It sucks that it's not, and it would be great if life was super simple, but it's not. It's not written anywhere that it's going to be, and you've got to learn to deal with it. And this especially bothers me with men. I think one of the problems we have with society is that we're not building men strong enough. I'd make the argument that a lot of men aren't actually real men, the way they act and the way they behave. And, in my opinion, we saw that play out in DeSanto's court. But we see it in other courts every day, don't we? Where everybody's got an excuse. Everybody can't deal with something. It's just so hard, blah, 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 blah. I don't know. That one bothers me. If you want to talk about that, feel free. And then there's one other case that I wanted to talk about. So if you want to hop on stage with me, now would be the time while I rack up this case. And if you don't, we'll probably call the 4th hour a little bit early because I do not have news stories or anything lined up for you today. I have something I'm working on, but it's not ready for the 4th hour yet. But this one is the Judge Stevens case with the guy with the 5th DUI. 5th DUI. This time he blew a .235, which is, what, 3 times the legal limit. Yeah, 8 times 3 is 24. I can do math. So yeah, 3 times the legal limit. He got a little bit of a punishment, but he got a 10-year suspended sentence, so it becomes 10-year probation, which, if we go through the statistics at his age and the fact that it's a DUI offense, he's more likely to finish it. But we also know that when you have the longer probations, they are not as likely to make it through that. So I think he's wasting his time. I think Judge is wasting the court's time, the system's time, and this man's time because he's not going to make it through. He was given 180 days in jail, which he's allowed to serve on the weekends, which I don't know how they work it in Texas. If he goes in Friday night, if they count the Friday as a day, in which case it'd be 3 days throughout the weekend. Some places do. If you serve any time on a calendar day, that counts as 1 day. If that's the case, then he's looking at 60 weekends. So, a year and 2 months worth. Or he's looking at 90 weekends, which is almost 2 years worth. I don't know which, but don't make any weekend plans anytime soon. But I don't see how this stops him. Now, I was thinking about this as we were listening to this case. DUI is kind of a funny thing for me. I know that there is a group of people out there who is just up in arms anytime somebody's nabbed for a DUI. I am not necessarily. Because you can get nabbed for one for some pretty pedestrian situations. You went out to dinner, you had 2 glasses of wine, you forget to use your turn signal when you're turning right, cop pulls you over, you blow a .09. Not the drunkest of drunk can be. You weren't out there partying, you were having dinner with your wife or your husband, and the next thing you know, you're in that situation. So in most cases, unless it's like an extreme DUI or there's an injury or something like that, in most cases for me, I think a first DUI should almost be something along the lines of a mulligan. Now, I'm not saying there shouldn't be punishment. I think a fine is in order, perhaps some classes, things like that. But I can see in most cases, I can see past that. I can see where it doesn't necessarily have to be a life ender, a life changer. However, when you get to, 2, 3, 4, and 5 with this guy, I don't get it. I don't understand why the system allows that to happen. Because a 10-year probation is just an exercise in futility. We know that statistically. 180 days in jail on the weekends, well, that's nice and all, but it's probably not going to stop him. They can take away his license. So what? He'll keep doing it. If you haven't learned your lesson at some point, I think you need to go away for a significant amount of time. But this This struck me as being punished too lightly for as many times as it has happened. And he did admit, as I recall, he did admit to being an alcoholic. So he shouldn't have access to anything, in my humble opinion. But you may agree or disagree. Barbara, thank you for the $5. And I hope you feel better. Michael, what say you?
First of all, yeah, Barbara, thank you so much. Barbara's been all over it today, despite not feeling well. So we hope that she gets
told
better.
her to take the day off, but she didn't listen.
Well, listen, Barbara's a free spirit. Barbara does things the way she does things, and we're always happy to see her here.
That she do.
So 5 DUIs. This is one of those things. I don't know, Dan. I get that. Yeah, people can be pulled over for DUI. Look, my mom got pulled over for DUI once coming out of a. So I was not here for this. This is my brief time while I was in Florida, but I guess I heard all the accounts of how it played out, and I guess she made a wide turn coming out of the parking lot of one of the bars there. She did not drink, but my brother and my mom's boyfriend, they had a couple of drinks. And so this cop pulls her over for making the wide turn, the big crime of wide turn. And of course, asks her how much she's had to drink, and I guess gives her a real hard time. And this was one of those stops that we would have seen in Judge Wiggins' court for being an extended stop, because they dragged this out as long as possible. And this officer, according to my mom, according to everybody that was there, said this guy got so pissed when my mom blew triple zeros. And, and she, and at the time, my mom was probably about, 60, a little over 60 years old. So, but it was one of those things that went on for like 30 or 45 minutes. I mean, if you can't determine someone is intoxicated after a couple or a few minutes, you don't need to extend the stop. So yeah, I kind of agree with you that they're probably a little over prosecuted and overdone. That said, you also can't take away the seriousness of somebody that anybody, I guess, conceivably could pick up one, but 5? And this isn't somebody like that blew a .079 and, we're sitting here kind of in that gray area, This is 235. That is serious drunk. I mean, that is I sat with my buddy one day. You met Johnny, right? So his father had a pacemaker put in about 17 years ago. And so Johnny was, all nervous, and it was just not a good day. So we went to the bar. We did what every, early 30-something would do, and we went and drank. And so it was just down the street from my house, but one of our other friends came over, and he happened to have a breathalyzer with him. So it was just for fun. We blew in the breathalyzer. I was drinking all afternoon, beer, mind you, but I was drinking all afternoon and only blew like a .11. I don't know how. Johnny was having hard drinks and blew like a .15, threw up in my garbage can out on the side of my house. My point in this is, how do you get to .235 without being like, how do you even get there? How do you not pass out? I mean, that's insanity.
I think this speaks probably to his level of tolerance and the fact that he truly is an alcoholic. I've referenced this before, but I remember watching Live PD once where the cops just did like a check on this guy who was walking his bicycle through a parking lot. And they dealt with him before he was a frequent flyer, and they knew him, but they had him blow, and he blew like a .323. And he was talking fine and walking fine, and they just let him go on his way. But he developed such a tolerance for it that
Michelle and I watched a very similar. We watched a very similar one. There was this lady was clearly drunk, but she was pretty articulate. I mean, was full sentences. I mean, we see some people that are 0.12 and they're just like, no drink. I haven't had too much, officer. So, but this was like, this lady was just coherent as could be. Yeah, okay, talking a little slow, yes, and she was walking pretty bad. But I mean, in terms of just if you just were talking to, like, you might say, yeah, she probably had a couple of drinks. That's about it. And meanwhile, she's blowing like a 0.33. Like, what is happening? So obviously, at least he admitted to having a problem. But I think the problem really is, and we've talked about this on Sidebar somewhat, the system enables him to continue because it does not take away his ability to drive. It doesn't really penalize him. It doesn't do anything to try. Maybe they've tried to give him some rehab or some counseling or something over time. Obviously has not worked. And so this is where we go from rehab to punitive, I think. We need to take away his ability to drive. I mean, come on. And the jailcation thing, you know how I feel about that. Not necessarily the biggest fan. Yeah, I want the guy to be able to keep his job and stuff, but I mean, this is DUI number 5.
Yeah, which I think is about 3 too many. I'm kind of the opinion, again, unless there's some extenuating circumstances like an extreme DUI or an injury to somebody else or something like that, that the first one should be a little bit of a mulligan like I described before. But if you go out and do it again, you know, at that point, you've probably just got to say, okay, if I go out and I have a drink, somebody else is going to drive, or, you know, I'm not going to drink. You learn your lesson, right? But yeah, I think after 2, I'm kind of almost becoming of the opinion at that point that you should just lose your driving privileges, period. And if you're caught driving after that, I don't know, 10 years.
I mean,
maybe
there's got to be something, or, you know, it's one of those things where you should have to go to some sort of, and I'm not necessarily saying inpatient, but some sort of intensive outpatient thing, or, you know, if you're after 2, because clearly if you've had more than 2, there's a problem. Again, anybody can get 1, I guess. But after 2, I mean, it's like, you know, mistakes are one thing, but yeah, outside of serious injury, death, you know, serious property damage, at that point, it should be about trying to rehabilitate. But once you get to 5, rehabilitation clearly isn't going to work either. It's about punishment at that point and protecting the community. And I think Stevens, as much as he lectured the guy and as much as he came down on the guy, kind of let him off the hook. I mean, and replace the word kind of with totally. Yeah. So that was my take on that.
He said that the 180 days was the most he could give him since he put him on probation. Which I get, but I don't think he should have put him on probation. But what do you think, Barbara? Should he have been put on probation?
I know, heard you. I'm getting ready to hopefully go live in a second. I'm just waiting to go on
Barbara.
stage.
You're on.
Huh?
He said he was.
Barbara, you're live on TCF 97.1.
I'm not feeling good.
Turn down your radio, Barbara.
I'm going to get through. Let's see.
Barbara. Hello?
Barbara, you're live.
Barbara? Okay.
Hi.
Hi.
You're live. What's up?
I don't know. Barbara.
Yes, I'm here.
Oh, there you are. Hello, Barbara.
Here I am. Hello.
We did like a whole bit on you there.
Yes.
So turn down your radio, Barbara.
I'm sorry.
It's all right,
I'm
Barbara.
sorry, my
You're
husband
good.
was in here. That's my husband in the background. I'm sorry.
No, you're fine.
Anyway.
So what do you think? Should this guy have gotten probation?
Absolutely not. I feel like his license. Can you not hear me?
Oh, we can hear you.
Okay. I do not feel like, I don't know what's going on with this darn thing. I guess I'm behind.
That's
I
why
don't
you
think that
gotta turn down your radio, Barbara.
it is turned all the way down.
Oh,
Okay.
Okay. Is this better?
Yeah, you're good.
I hear
Maybe
you.
not. Okay. I feel like the guy should have his license revoked. I'm sorry, but 1 and 2, 3 is enough for me. But 5, come on, man, that's ridiculous. If he doesn't kill himself, he's going to kill other people. And how many victim impact statements have we heard where they're getting a slap on the wrist, that the probation for 10 years or whatever it is, which they never make anyway because they can't stop drinking, even if they have the sober link on their ankle, it doesn't matter. You know what I mean? 5 is too many. And I think it puts, they're so worried about their communities and making sure everybody's safe. Well, I don't think that's the way to do it. 5 is ridiculous. It's crazy. So I think that he should have gotten his license revoked, period. And I feel very strongly on that, clearly, for me to get up on there today feeling as bad as I do. And nope, 5 is way too many.
I agree. I'm of
Same.
the opinion.
Yeah, I agree.
I'm at 2. I'm at 2. The first one's a mulligan.
Yeah.
The second one is you don't drive anymore.
Exactly.
At least not for an extended period of time.
Yeah, and if you're caught driving after that, 10 years. I don't know. I don't think it has to be that difficult.
And the judge should take you over his knee and spank you, a la Judge Fleischer.
Now, that'll get our judges taken off stream. We don't want any more of that.
I'm telling you,
other
but
thoughts,
seriously,
Barbara?
I mean, when I see these DUI cases, yes, when I see these DUI cases, I mean, it really, well, you know, the ones that really upset me, but the DUIs, come in second because it's, how many do we see on a daily basis? That's what blows my mind. It's almost like it's okay to do, and it's to do. And with the judges handing these candy sentences, I think it's ridiculous. The hell with the interlock device and all that stuff. No, you just don't drive, period. That's really all I have to say. But really, clearly, it angers me because, no, I don't drink, first of all. But that doesn't matter. I'm speaking for everybody to keep everybody safe. That's not the way to do it. Because as soon as he gets another chance, you already know what's going to happen. You already know. I guarantee you this guy's going to be back. Just like the young lady.
Statistically, he'll be back.
Right. Now, I know we're not talking about this case, but Judge Stevens, the young lady that was started to cry. Well, it's too late to cry now. You should have thought about that before he gave you all these chances. The one that he sentenced to 5 years.
Mm-hmm. No, I totally agree.
It's like, come on. How many chances to you, if any of us in this did any kind of crime, there's no way we would get off that easy. I believe that. There's no way. We wouldn't be that lucky.
Yeah.
But I'll never step foot in Texas, I can tell you that. Not that I do anything wrong, but my Lord. No way.
I don't know.
So,
it depends on
anyway,
what
that's all
kind
I
of
had to
crime you're
say.
going to do in Texas.
Well,
All
I'm
right, well,
not
thank
going
you,
to do
Barbara.
any crime. Yep, thanks you guys. Hope you have a good day. And sorry, I just haven't been
Feel better, Barbara.
under the weather. I'm sure you can tell.
No.
So, thanks,
I'll get
guys.
some rest.
I'm gonna sign off.
All right.
Yeah. No,
So-
certain crimes in Texas are definitely different, or handled much differently than you would think.
Well, yeah, the things you'd think they would come down on you, they don't. But that's a weird thing that we see here is that every area just seems to have their things that bother them.
Right.
In Florida, it's fishing.
Yep. Hunting out of season.
Yep.
Without a license or whatever. I mean, that's like that guy. I still can't get over $42,000 bail That was
Yeah.
Then who was it from the NFL that's there on an what was it, like a aggravated
Antonio Brown,
assault?
attempted murder.
Right, attempted murder, 25,000. Fish. Meanwhile, up to the north and up there in good old Jackson County, up in the Panhandle, Judge Mercer's handing down $42,000 bail for I mean, multiple counts, mind you, but still for hunting without a license and fishing out of season.
Yeah. I don't know. The justice system is weird. I mean, I believe that more and more things should be controlled at a local level. We've talked about that before, but then in the same respect, when you look at this stuff nationally, as we do here on TCF, and then you see the disparity of things, it's kind of crazy. You know?
Yeah. Well, and the other thing, Dan, that I wanted to touch on just real quick was we should at some point, try to put together like the worst of TCF or the dumbest things on TV, because that guy snatched defeat from the jaws of victory today.
He sure did.
I've seen it a couple of other times. I want to say there was a case like that in front of Judge Fleischer even. I know I've seen it where somebody has a great deal worked out. Oh, Judge Mogan, very famously, she had a guy that she did not want to. There was this plea deal. She was begrudgingly accepting it. This was many months ago. This is over the summer. And she did not want to accept it, but he stumbled or he sort of said in his allocution that, well, there was some other people that did something, like he didn't completely allocute, and Judge Mogan immediately just goes, all right, we're going to set this for trial then. See you next time. See you later. So she immediately, because she wanted so badly to have a trial for that guy and actually sentence him properly, because she even said that she was not happy about the sentence, but she was going to accept it. But yeah, then once he kind of screwed that up, so that would be I'd have to go back and try and find that one, because that's definitely in the top 5 also. But today was incredible, and especially in front of Judge Middleton, who was being pretty chill about the whole thing, and as he always is, and that was crazy.
I know. I don't understand what that guy was hoping to accomplish there. Especially when he just flat said, yeah, I took it, but everybody takes it. It was words to that effect. I mean, why?
I wrote in the chat, it's like, it's owing $59 million on ever being able to use that as a defense and having it work. I mean, it's so far still, it has never worked. Yeah, I did it, Judge, but here's the thing, like everybody else, there people were stealing crap out of that yard all the time, Judge. Like I only stole one. This other guy took like 5 things, and that's never worked.
Yeah. I was about to say, can the guy be that dumb? But that question kind of answers itself, so you don't even need to ask it. Barbara says, I don't want... Barbara says, I don't want to interrupt the show, but 5 DUIs, it's way over what I can process. You didn't interrupt the show at all. That's the whole idea. That's why we do this, is to be able to call
that's the point, Barbara. That's
I will say,
and besides that, it was
cutting in and out a little bit, but
a little.
That's the whole idea.
But it's
No.
But still, right.
Yeah.
I don't know, Dan. This is one of those situations where I'm just not sure.
Maybe
really
they should have had him
left.
Maybe he'd been drinking this morning.
Are you making this freely and voluntarily? Are you drunk today, sir?
Yeah, you almost should have put him through those questions. I mean, I there's not a procedure for that. I know he can withdraw his plea, and that's his business. But yeah, you almost should have asked those questions, because I don't think he was in his right mind.
There are so many times, and this should there's so many times, and maybe this should be merch, Dan, but sometimes people just need a glass of shut the hell up. Just listen to your lawyer, shut the hell up, and follow the agreement. You're not going to talk yourself into anything better than out of a felony and into a misdemeanor. What does he think he's going to? Well, if I just keep talking, I might get out of here scot-free. Like, no. So I don't know. That was classic, though. I mean, don't get me wrong, entertaining, but highly frustrating and stupid.
Charles asked if there was a jailhouse lawyer type of thing. He was not in custody, though. So I doubt it. Maybe a friend, but not a jailhouse.
One of your know-it-all buddies.
Yeah.
Yeah.
Most.
Hey, dude. No, man. Don't take that.
Most people are stupid. Don't take their advice. It's a safer bet, especially nowadays.
Yeah. Bro, if anybody starts a sentence with bro, don't take the advice.
I see that all the time over on the Kick side of this stream, where people are trying to get me to sign up for their BS services. Bro, I'm watching your stream. It's so cool. Yeah, okay. Ban. Yeah.
All
right.
So, so anyway, Dan, that was a lot of fun today on TCF. It's always an exciting day.
Well, Beth just sent me a downer to end of the day on. Do you want to stick around for that?
Okay, let's. Sure.
You're like, do I have to?
There. All right, here we go.
Why aren't you?
Where did I go? Am I here?
Well, that's what I'm trying to figure out.
I disappeared into
the
the
void. Do it
void.
that way.
Okay.
Well, I tried to remove you from the void, but it wasn't. You were just there.
I was caught in the void.
It happens. So she stumbled across this while we were chatting here. Babysitter reportedly said she fell on infant who suffered head trauma, lost part of skull. So this will be an interesting thing to follow. 2 weeks ago, Tori Nelson reportedly got a message from a babysitter of her 3-month-old son, Braxton, no parent ever wants to receive. Chris Musselman, Braxton's father, told YourCentralValley.com that the babysitter said she fell on Braxton and then woke up to find the infant, quote, unresponsive. She fell on Braxton and then woke up? That's an interesting statement. So was she drunk? Let's keep reading. With that, Braxton was rushed to the emergency surgery for severe head trauma. We barged in the emergency room where the ambulance goes, Musselman said. We got yelled at by security guards. After a 6-hour surgery, doctors shared more bad news. He explained to us that the injuries weren't consistent with a fall. They were consistent with the baby having been shaken. And at that point, the doctor had no choice as to a mandatory reporter to involve Child Protective Services and other authorities. With that, 50-year-old Tanya Hamilton, the non-relative caregiver of Braxton, was arrested and booked into the Madera County Jail in California on felony child abuse charges. City of Madera is about 30 minutes northwest of Fresno. As you might imagine, Braxton's parents said the days since they've gotten word about their son have been a nightmare. He cries, but his cry is different. You know your babies cry and like what they want and need. I just don't know anymore. Musselman added that it's been absolutely tragic. No parent should ever have to go through this. No child ever having been treated this way. I was heartbroken to see my son that way with all of the tubes, and just like in the state he was in, he never asked for this. Good news is Braxton is no longer in ICU and no longer on a breathing tube. Well, that's good. And a GoFundMe has been set up. So, hit the right button. There we go. So, thank you, Beth, for sharing that. Sadder way to end the day, but this, and it's in California, so unfortunately we're not going to see. Yeah, I lost your audio, Michael.
Hold on. Sometimes stuff breaks. Yeah,
it sure does. But I mean, it's in California, so we're not going to see this streamed. But it's a story we can continue to watch, but what is up with people? What is wrong with people?
Shaken baby is, yeah, I mean, great that he's not in ICU. And I mean, that this is a kid that now probably will have to have lifetime care. Barbara, get the wood chipper fired up. I mean, this is things like that. Just, I don't even have words for them. I'm usually pretty able to articulate myself on issues like this, but it's just sometimes the only thing I think of is just heartbreaking. Like when you were reading that, I just felt the air just leave the room, because it's just, and then of course you feel just anger because you can't believe, and disbelief. You just can't believe someone would do that. I mean, I get, some people are not adequate to handle a crying baby or whatever, but that doesn't mean you pick it up and shake it. And then to come up with, I fell. Okay. And that's obviously, the facts belie that statement. So, let's keep an eye on that story, I guess, and see what happens to her. I thought we were going to do a follow-up to the Chuck E. Cheese guy who was taken away from Chuck E. Cheese. Remember, I think we talked about that over the summer. He was led away from Chuck E. Cheese, like is still in the uniform and stuff because of credit card fraud.
Yes.
Well, he had a plea deal, and I guess, yeah. I thought that was what we were going to follow up. I was like, oh, what a fun way to end the day. Oh, no, just shaken baby syndrome. That's
no. Beth
really
decided
sets
it'd be
the
a good
tone
idea
for a
us to
Wednesday.
end on that. But I will say this. This is so thank you for your contributions, honey. I appreciate it. But I will say this. It speaks to what we see so often across the nation, and that's that we're not protecting those who are most vulnerable. We're not acting responsible with them, and unfortunately, when they get to the court, these things aren't necessarily handled well. Now, this is a violent act, so I'm guessing that the person will probably get more of a sentence than they would get with, like, possession of images and stuff, which I still don't understand why we go so light on that.
Or just, like, ripping off from the elderly or whatever.
Yeah. But I don't think it says a whole lot about our society and its current condition when we can't even protect our infants, because they're, this is cliche, but they're the future. It's the continuation of the human race, and when we start messing with that, I don't know. It's like we've lost our instincts.
Well, yeah.
It's
I just want to know what snaps in someone's brain. Like what happens that the switch gets flipped or something just breaks where they just go, I can't cope with this, so I'm going to just shake the baby. Like what happens? Where do the instincts go? Where does the humanity or the empathy or just, why not just walk out of the room, take a breath? Where is that? Do people not have any means of coping anymore? Is there no? Yeah,
it seems
I
that
am
way,
just
we had
befuddled, perplexed, baffled.
We had the guy in DeSanto's court today who's like, I can't cope without my marijuana. I'm shaking because I'm so nervous. I'm like, are you kidding me? Life is not that difficult. And if it is that difficult, you're doing it wrong. And I'm not saying everything's simple. And I've had 4 children. When you have a baby that's crying, especially if it's going on for hours and you can't figure out why it's happening and you can't get it to stop, is it frustrating? It really is. You'll pull your hair out. But you know who else is ready to pull their hair out? The baby. Because the baby has 0 communication skills, 0 life experience, has no idea what's going on. It just knows it has a problem. So, I don't know. We need to do better. Pray we all do better. I guess that's the bottom line.
We do.
Michael, give me something happy to end the day with.
Yeah. Do better. Do world. Something happy to end the day with. Boy, I'm having trouble. Hey, it's going to be a beautiful day. 75 degrees today.
Is it?
75 with some clouds. Just a perfect, beautiful day out there today.
So I should step outside.
High temperature this afternoon, 75. Yes. Step outside, touch some grass.
Do we have grass here? I'm looking out the window. I see stones
we do
and
out
some
in our yard
weeds that have popped up from recent rain. Just
All right.
stepping
touch
on
weeds.
weeds and
smoke
stone
weed,
kind?
touch weed, whatever you want to do.
All right. Thank you, Michael.
Thank you,
Have a good
Dan.
day. Michael Groff, ladies and gentlemen. By the way, Barbara, if you're still out there, drop a link to Michael's channel. If you're not subscribed to Michael's channel, go fix that. He does Arizona weather, which may not be your thing, but subscribe to him anyways because he's worth it. Tim says, I have grass. Good for you, Tim. We don't have grass here. It would just burn up if we did. All right, friends, we'll call it a day there. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour early for channel members, and we have Sidebar tomorrow as well. What are we talking about? Don't know. We got to figure that out today, but we will. I hope you had fun. Barbara said it's been an intense day. It kind of has, but a worthwhile day. So thank you all for joining me. Go have yourselves a great Wednesday. See you tomorrow. Take care. God bless.